Thank you, Mr. Chair, members of the committee. For the record, I'm Marjorie Porter from the Switzerland of New England. And I introduced this bill, I bring this bill forward because of a concern that I have that with all of the new people that are coming into our system to educate our children, that the children are safe from predators and other folks who should not be dealing with them. I filed the bill originally after hearing about the Prenda program, which is quite possibly a wonderful program, but is designed so that they are pods of people working together with a teacher that doesn't have to be certified. So the person that is leading the group does not need to go through the Department of Education to get any kind of requirements. And that concerned me because the idea, as I understood the Prenda program, was that these small groups of people, children with one adult in a spot that would be chosen by the adult, was a potential for some unpleasant experiences. So I brought this bill forward. It requires that anybody who is working with children as part of a program that accepts public funds should be required to have a background check, as all teachers and teachers' aides and other folks in public schools do. And with that, I'll be glad to take any questions that you might have.
Thank you. Thank you, Mr. Chairman. Thank you for taking my question. How about volunteers that may come in for a day or two?
Thank you for that question, and it is a concern. I know when I ran my private preschool and kindergarten, there were high school kids who came down as part of their program of outreach into the community, and they had to be background checked. So volunteers in public schools have to be background checked when they come in and work with children. It's to protect the children, especially in situations where there's no direct supervision over these folks. So there's not another adult in the room. There's an adult and a group of children, or adult and one child. You just want to make sure that those kids are safe, that's all.
Thank you, Mr. Chairman. Thank you, Representative. I'm just wondering, what is the intent in relation to Section 1? It's a new section.
Yep. It's to make sure that anybody who is an employee or a volunteer of any entity contracted for educational service by the Department of Education who provides in-person instruction shall comply with having a background check. So if the Department of Education or if a family is hiring a tutor to tutor their child, that tutor should have a background check because that tutor is working with a child without another adult supervision, just as in the public schools they would need to. So the purpose is to make sure any person or school or provider that's receiving our tax dollars should comply as our public school teachers do need to.
Thank you. A tutor hired by a parent might not necessarily be employed by the Department of Education or certified by the Department of Education. So I'm just wondering if there are any other people who might meet the criteria of Section 1.
My understanding from what we heard the other day from the folks who administer the scholarship fund, that they do require all providers to go through a rigid background check. If I understood what they were saying, it's a concern of mine, Representative, that anybody who is hired to work with a child and is getting paid with tax dollars, that person is a safe person to have around children. And I'm not sure how I could make it more clear.
Would this still hold if they were not alone in the room with the kids?
Yes. everybody that works with a child should have a background check to make sure that they are not of a nature that might do harm to the child.
So that was one. I have a second, yes, thank you. A second question, which is who authorizes and does the background check? Who does the background check come to, the results, who do the results come to, et cetera? How does that actually work?
That would have to be established by the rules of the department, I imagine. And I believe they have rules already for background checks for some people who are being, who are working with the Department of Education. Didn't the Learn Everywhere program, they talked about how all those programs, everybody that works with the kids has to go through the background check before they are approved for the program. So I'm hoping that with all of these new programs we have now, we have Prenda, we have Learn Everywhere, we have EFAs where people can take their children anywhere to be educated, that the people who are working with the children are safe people to have working with children. And the department would, I'm sure, have to figure that out, or the scholarship granting organization, or whoever else is recommending or paying these people to provide these services.
Further questions, Representative Luno?
Thank you very much, Mr. Chair, and thank you very much, Representative Porter, for bringing this forward. So, would you say that that this bill, which certainly has a lot more to it than the legislation that formed the so-called Learn Everywhere program, that a process like what, or like a process like what the department does for the quote Learn Everywhere program could number one help to assure that you've got people that have cleared criminal background checks, and number two, really put the department in a position where they could be a clearinghouse, a huge support for parents that may be homeschooling their children and want to see a list of tutors, let's say, that have cleared department criminal background checks. Very much like the Learn Everywhere program, an enormous assistance to homeschooling families.
Yes, I think it would be. And, if I were a parent and I was hiring someone to work with my child, I'd want to make sure that person wasn't someone who has a background of abusing children. I mean, it just makes sense that I would know that, want to know that, and simply saying to the person, you don't have any background abusing children, is not a good guarantee. So I want to make sure that any child that's getting services that tax dollars are paying for, that those people that are providing those services are on the up and up. We hear so many horror stories. I've heard horror stories in my own town. It's not a good situation when someone who has a bad background ends up with a group of children. It's just not good.
And a follow-up on that,
Yeah.
Mr. Chair? This is specific to family students who are receiving public dollars to fund their education. Why can't they go and just do the criminal background checks themselves? It's a rhetorical question.
They could, I suppose.
No, they
but
can't.
I don't know if they're
Is
allowed
that-
to do
so-
that.
yeah,
I mean, they can't get private records. I don't know.
Certainly for the multi-state.
Right.
Further questions from the committee? Representative Cordelli?
Thank you. I'm just looking at lines 15, 16, section 3. If someone has a tax credit scholarship, for instance, and is doing a home education program, are you saying that the parent needs to have a background check?
No.
How about, I'm sorry, follow-up?
Yes, go ahead.
I know a lady in town who is doing a history program for about 10 home-educated high school students, and I think maybe someone in that group has a tax credit scholarship. Would the woman conducting that course be required to get a background check?
Is she being paid with those tax credit dollars?
I don't know if she's being paid or not.
If she's being paid with tax credit dollars, if she's being paid with taxpayer money, then she needs to have a background check. If she's working with a group of children alone in a room and she is receiving public money, she needs to be safe for those children.
Yes.
I think, and we can talk about this more, but would you agree that the courts have indicated that via the tax credit scholarship program or education savings account, anything like that, where the dollars are going to the family, that is no longer public money that is being paid to the service provider? Are you familiar with those court rulings?
Yes, I am, and I think that that's the equivalent of money laundering, in my opinion.
Representative Tanner.
Thank you. And there's still court cases pending on that in other states. Okay, sorry. Is that better? Yep, okay. So one of the things about this bill is that you're asking for background checks under RSA 77-G:8-A, which is something that we've been talking about. Representative Mullen had some additions to it about like trafficking, human trafficking and stuff. Does this up the criminal background checks that are currently being done by the scholarship organization? In other words, some of these places that say they're doing criminal background checks, are they really doing this 77-G?
I don't know, Representative, what the scholarship organization is requiring. I don't know what section of law they're going under. This specifically mentions 189.13A as well as 77G7.
But this makes it clear that you want them to have
We want them to have the same criminal background check that a public school teacher would have, or a public school paraprofessional would have, or anybody in a public school system would have to work with our children.
Further questions? Representative Nelson.
Thank you, Mr. Chairman, and thank you. I'm sorry for another question. 4 and 1, coming name 4 organizations. The 4-H, the teacher goes in to give a little history class on the State House, Tin Mountain Conservation Service, and bringing a guest speaker into a school. Would they all need these checks?
If they're being paid with public dollars, according to this bill, they would be. If they're volunteering, most likely not.
Okay, thank you.
Representative Likas, you had a question?
Well, I just had a follow-up because you keep emphasizing if they're alone in the room, and yet when I ask, you said even if they're not. For instance, if a parent hires a music teacher and sits in the lessons the whole time, that music teacher still needs, I just want to make sure I'm understanding, because the parent's there the whole time the teacher's there, that teacher would still need a background check.
According to this bill, if the teacher was being paid with public funds, then the teacher would need to have a background check.
Okay, thank you.
Any further, yes, Representative Hobson.
Thank you, Mr. Chair, and thank you for taking my question. I just was looking at the fiscal note on the back. It indicates that the cost is indeterminable. I was wondering if you could speak to that.
No.
They can't, the follow-up?
Yes.
The Department of Education, can you tell me who would be paying for these background checks? Would it be the person applying or the DOE?
I would imagine that in order to get set up to be a person who is providing educational services under any of these programs, that they would take it on themselves to pay for it. The people who are providing these services are not employees of the state, but they are receiving public money. So therefore, it needs to be, I feel they need to be sure that they are safe to deal with children. I mean, this is not a complicated issue here. This is a child safety issue. We don't want to find out 5 years from now that there was some kind of an organization that was using these kinds of programs to get in and work with our children. I just think it's a protection for them. It's not a harmful thing. It shouldn't be in anybody's way to say you can't provide the services. Parents should be eager to do this because they want to make sure that their kids are safe. And I just want to make sure we have it in the law that, yes, these things are required so parents can be confident. That's all.
Thank you.
Thank you very much. Are there further questions? Representative Cornell.
Thank you. Thank you for taking my question. If I remember right, a million years ago when I became an educator, I paid for my own criminal background check before they would hire me. And I think that's still the way it is now.
Well, I know when I had my certificate extended to the state of New Jersey and Pennsylvania, I paid for my own.
Representative Woodcock.
Thank you, Representative Lyon. Representative Lyon, just a clarification, if I may. Where I see that Attorney Fenton is here, maybe she could just give us some clarity on the question of, does the scholarship, it's been purported that the scholarship organization provides criminal background checks, and it hasn't been discerned if the background checks are equal to or similar as our current background checks we do for all the other staffing. So perhaps you could give us that information.
Yeah,
Technical advisor.
I plan on asking the department if they have any technical advice for us on this, or
Would you
we'll
include that
take
question,
questions. They
please?
have not submitted a pink card. So at this point in time, I'm going to continue with
But she's right
the.
there.
Pardon me? Well, we've had her as a representative senator, and we've had her governor too, so, you know. So I mix and match, and I'm sure she appreciates.
Perhaps that young woman in the back with her pink card could answer the question later.
Thank
Thank you,
you for
Representative
the
Ladd.
suggestion. That would be wonderful. That's wonderful. Okay, so we're going to continue with questions here for Representative Porter. If we have questions for Representative Porter this time, and then we'll get her off the hot seat and get some others up in front. We do have one other card that's come forward.
Representative, can I just put forward a thought as I'm thinking here concerning whether the money that's going to education freedom accounts is actually taxpayer money or not. When citizens receive food stamp help, when citizens receive Medicaid, when citizens receive other services that are provided by the government, is that not taxpayer dollars going to those programs, even though they're going through Medicaid, they're going through the food stamp program? They're still taxpayer dollars, and so that is why I believe that this is important. That it's my money going to pay this person. I want to make sure my money is being used by someone who is worthy of working with children.
We'll note that down as part of your testimony. I'm not going to respond to it. We're not going to take questions from the people that are presenting. So then we will ask that, are there any more questions for Representative Porter? Yes, Representative Ford.
Thank you, Mr. Chairman, and thank you for taking my question. My question has to do with service such as I performed. I have former school board member. I volunteered to be like a para assistant in the schools just to see how things were working. I didn't know. And so I did that. I had to have a background check for it. That experience makes me wonder if for that large number of people who might, and I say large because there are a lot of them who do come into schools to give presentations and talk about what they do and whatever. I wonder if the key factor is, and they're not paid, they just come in and volunteer. Right. So they might slip through this radar and yet still be a threat to a child. And so in that, I'm thinking maybe that there ought to be some provision for unescorted people or some other definition added in addition. I know your concern is the dollars, but I'm thinking of the intent of the bill and just thinking in the same way, might it be a good idea to also put that such people must be continually escorted, never left alone with children?
It's a possibility. Thank you for bringing it up.
Further questions? Not seeing any. Thank you very much. And at this point in time, we have Ms. Tuttle, here to present too. So before we get to our colonel here in the back of the room, then I'd like to have Ms. Tuttle come forward. Thank you. Welcome.
Thank you, Chairman Ladd, and members of the committee. I'm not sure what to say to that. For the record, I'm Megan Tuttle, President for NEA New Hampshire, representing 17,000 public school educators across the state. I do have written testimony I'll pass in, so I'm not going to read the whole thing. Just very simply, we're here in support of this bill. You know, the intent of it is to have anybody that's working with children receiving public tax dollars to make sure they have the same background checks that educators in the schools do. I know that as a volunteer on PTO for my third and fifth grader, just going into the school to do anything for PTO, I have to get background checked and fingerprinted, which I did. I'm somehow still on the middle school PTO, even though I don't have children in the middle school right now. I'm not sure how that worked, but I had to get it's the same fingerprinting process for all that. So, we're here in support of that. If we look just this year and last year, legislature and the DOE have undergone several initiatives and law changes to make sure that the background checks were thorough, and you've added, I shouldn't say we've been in support of adding different violations, et cetera, to this. We have our Educator Code of Conduct, which I always have my copy with me. And so, that's been passed through. And so I think just the intent of this, with everything that's been done in the past few years, it should just happen. I don't really know why we would hold a private provider to a different standard than we hold the educators in the public schools to this. So I think this is a really good opportunity to correct this, and just urge everyone not to pass.
Thank you very much. Are there any questions for the NEA? You're off the hook. Thank you very much.
Thank you.
At this time, we'd like to have the individual from the Department of Education. Diana, welcome. Well, you can be a full colonel or a lieutenant colonel, light colonel.
I guess I'll just have to stick with lawyer.
That's great. Thank you.
As I always tell people, as a former prosecutor, believe me, I've been called worse, so I will take the names you've been giving me. So I want to provide a little bit of clarity when it comes to volunteers, because volunteers are always a conundrum. The law 189.13a sets out that volunteers are determined by policy, school district policy. It is a local issue. And there are two groups of volunteers. There's volunteers, and then there's designated volunteers. So each school district will have a different policy that talks about what is, or who is, a designated volunteer. And the way that I always explain it is, if I were to go to my son's school for the Valentine's Day party, most likely I would just be viewed as a volunteer and therefore not subject to the background check. But if I were to volunteer on a weekly basis, participate in teaching the chess club or the ski club or whatever school affiliated activity, then I would be a designated volunteer and I would be subject to the background check. With all the work that this committee and the House in general has been doing on 189.13a, I will share with you that the majority of school districts have had the opportunity and the reason to go back and revise those policies. So I commend you for that, because I know that those policies just hadn't been looked at. It wasn't out of malice. It was just out of everyday life. But due to the work this committee's been doing on this important area, a lot of those school districts have had the opportunity to revise that. But generally speaking, that's the lay of the land when we look at volunteers. I can also tell you in very general terms, I would think of myself as someone who's pretty adamant about child safety given my background, and I think this committee would agree. But I really pale in comparison to the commissioner. I honestly have never met anyone who is so child safety focused. And so all of these programs that the department is doing, I know that the commissioner and I have spent many hours talking about how we incorporate the background check into it. So with the Learn Everywhere program, I know in the rules, and they are currently revised and going through the JLCAR process, there is a provision in there that I'm happy to share with the committee that talks about that each entity has to have a policy that follows 18913A. They are subject to those parameters. I will remind this committee that 18913A sets out those, as we call them, those Section 5 violations, right? That's kind of the floor, if you think of it. I always compare it to the federal Constitution. That's the floor of protection. Each district can adopt a policy that allows them to be more protective. Look at other offenses that fall outside of that Section 5 violation. And so that's where you will see from district to district, from program to program, discrepancies and differences. That's that local control piece that's at play. In terms of this particular bill, again, the department's not here to support or oppose. I would suggest that we be consistent with our statutory numbers, where we look at, on page 1, line 17, the checks under RSA 77G8A. If the intent is to be in compliance with 18913A, I think that has to be throughout. There was a question about the fiscal note. I completed the fiscal note on behalf of the department. The cost was indeterminable because looking at the language, especially at the top of the bill, lines 3 through 6, looking at it as an attorney, I felt that it was overly broad. And so it is impossible to calculate what this encompasses. When you look at any employee or volunteer of an entity contracted for educational services, that is very fluid. That concept is very broad, and so it's hard to quantify that. And so that's why we had the indeterminable number.
Thank
I'm
you.
happy to take any questions.
Thank you. Are there questions for Attorney Fenton? Representative Luno?
Thank you very much, Mr. Chair, and thank you very much, Attorney Fenton, for joining us this morning. You had mentioned just now that the new rules, I guess, pending before JLCAR with respect to the Learn Everywhere program require the Learn Everywhere providers to follow the procedures outlined in 189:13A. And one of the procedures that really jumps out at me is found in 13A Roman 2, where an applicant for employment with the school, in fact, it says with a school administrative unit, school district, charter public school, or public academy. So it doesn't specifically call out Learn Everywhere programs or education service providers or whatever terms the department wants to use for tutors, service providers, things like that. But it's certainly pretty broad, historically captures, up until Learn Everywhere and voucher program sort of captures the network of education providers in the state. But anyway, that a prospective employee submit an authorization submit a release that authorizes the state police to conduct a criminal history records check through its state records and through the Federal Bureau of Investigation, and to release those reports to the superintendent or designee of the school administrative unit or the chief executive officer of the charter public school or public academy. I was wondering if you could say how that works for service providers in the Learn Everywhere program and in the voucher program.
As to the mechanics of it?
Yeah.
So I will have to get back to you, and I'm happy to do that. That's more of a Department of Safety issue. The Department of Education does not house and maintain those records, and so who the records are being released to review and make that determination, excellent question. I will link back with our partners at the Department of Safety and get you that answer.
Okay, and a quick follow-up on this, and this may be a get back to us on it as well. But if I'm a parent of a student of an EFA student, and I'm interested in hiring a tutor, can I request the state police to conduct a criminal history records check, and as well as the FBI I think that's a multiple state records check, have that information released back, directly back to me as the parent of an EFA student?
So, again, I'm going to do let me talk to the Department of Safety and get back to you. The Department of Safety is regulated by very strict FBI regs. I have a cursory understanding of them, but I don't want to misspeak. So let me talk to them, and I can get back to you on that.
And one final follow-up along this
One
very
last one.
technical line of questioning. However, the department does complete criminal history records checks for, let's say, school bus drivers. And that information is released to the department. Is that correct?
Yes.
So the department has the ability to do this.
Yes, so when you look at 18913B, which pertains to the bus drivers, and we've talked about that previously, and 18913C, which pertains to first-time teacher applicants, those are newer initiatives that the department is undertaking. So yes, the department is a governmental entity, and we can work with our partners at the Department of Safety and receive those background checks and process that. So as we have discussed previously in my prior testimony, that is a role that the department is taking on. That infrastructure is fairly new. We are currently building it. But yes, that is something that we are facilitating.
Great, great. So the outstanding question then is, how do Learn Everywhere providers do it, and how would a parent of an EFA student do it?
Yes, and I can get you those answers. I just want to double check with the Department of Safety because they get really crabby when I speak on their behalf and I don't work for them, and they're pretty well armed. So I'd like to make them happy. So I appreciate
Thank
it.
you very much, Diana.
Thank you.
Further questions? Representative Tanner?
Thank you. I have actually two questions. One is that I know words really matter, as coming from a teacher into this legal atmosphere, even the may, shall, business. So I'm wondering what the word follows is used in legalese. When you said that they follow, does that mean they shall, they are required, they may? What does that mean?
Thank you for the question. I'm just going to pull up the Learn Everywhere rules that I have here. Because I think so the language that I used was simply that. It was my language. If you look at the language in the Learn Everywhere program rules, it is a mandate that the program providers have to follow the law as laid out in 18913A. So what's applicable to educators in the public school system is equally applicable to the service providers. So that's the language. Looking at it, I don't see that word following. That was just a word that I used.
Okay, didn't have the significance I thought it was.
Oh, that's okay.
That's okay. My other question is about the scholarship organization. And do they use the same set of criminal background checks that the educational systems, the educators have to use in public schools? And do they check all the employees of the organization as well as the people that they're vetting to release the public funds to through the EFA?
I believe that they do. I don't want to misspeak, so I'm going to do I will get back to you on that exact answer. Because again, I just don't want to mislead. But I believe that when we look at these issues as a department, and recognizing the importance of child safety, and that's never been in doubt at the department, we always refer back to 18913A. That is our guiding principle. And 18913B and C were all premised upon that. So we use that as our structure, and we don't deviate from that. And so I know in speaking with the commissioner, it's been very clear as a policy of the department, that's the application, and the application is consistent across the board. The implementation, right, again, we're going to defer to these entities to have that policy that is consistent with, pursuant to, whatever word you want to utilize, that law. That is the law that we always go back to. That is the criminal history background check law. So I think that piece of it will always be consistent throughout those programs.
Okay, Okay, just follow up?
Well,
question?
you said two questions.
Oh, well, this is kind of a follow-up
Is that on
because she
that question?
expanded
Okay,
it, yeah.
fine, go ahead then.
So, one of the issues I remember dealing with in the past was that, for example, Learn Everywhere might have a contract with a small business that has employees that that person is working, the student is working with. And as a person that's an employee of this third party, they do routine criminal background checks and credit checks on these people to employ them. But their criminal background checks are, you know, for like stealing and things that they don't flag in particular, like trafficking and child sex abuse and, you know, some of the things that we have.
It might not be child safety focused.
Right, okay, not child safety focused. And so when you say they're following our guidelines, are you saying that they're doing criminal background checks, but we're really not making sure that they're using the criminal background checks that have child safety, specific child safety issues involved in it?
Well, again, speaking in very general terms, when the department looks at these programs and implementing them, I can tell you that this has been a very robust discussion at the department, and these programs are not administered or implemented or started without this being a consideration. I can't even begin to count the number of hours that the commissioner and I have spent talking about child safety. And again, we always go back to 18913A. We recognize that individual private entities might not have those child safety focused policies. And so that is why you see language such as you need to have a policy that is in accordance with that criminal record law that guides all of our actions when we look at child safety and working with children.
Okay.
So how that's implemented on each individual program, I want to get back to you on that because it's very detail oriented. But in a broad policy sense, there is not a certain program that goes by the department that doesn't reference that law.
Thank you.
Thank you very much. Representative Litchfield, did you have a question?
I did. Thank you. I think you might have answered it just now, though. So I think I'm looking for a teachable moment for me, selfishly. Having I sit currently on a couple of school boards in a very large district, and we've gone through these policies that we're discussing right now as far as child safety is concerned, and we've gone round and round many times about to what extent do we do a background check on the volunteers? Does it make sense? Is it cost effective, and would it really make it safer for the children? So my question is, I know Rep. Porter has just mentioned that she's heard some horror stories in her district. I know that there are probably a variety of background checks, but my question is, if we were to actually do these background checks, how much information do we actually capture? Is it only if someone has actually been convicted? I'm just curious how effective it is to do these background checks, and if it is done through the DOE, does that impact the liability for the DOE? And I'm going to take it even a step further. I feel like safety is absolutely important. I have 4 children myself. That being said, I witness even at church, people are afraid to help a child in the restroom because I could be held liable for this. So I'm kind of doing a little dump here and hoping you can help me out.
I think in my past job we'd call that a compound question. Well done. You did it very well. All right, so a couple of things. When you look at the law, and you look at the Section 5 violations which are set out, it says if a person has been convicted or is currently pending disposition for, and that's just a fancy word for awaiting trial. And so it captures the conviction and it captures the pretrial piece of it. Historically, I can tell you when I started with the department in 2015, what was being released by the Department of Safety to the individual school districts, because the Department of Ed was not playing a role in this issue at that time, was simply a letter. And the letter simply said the person has a Section 5 conviction or they don't. And I can tell you when I first saw this letter, I said, what is this? Because I had come from a very different world, a very different background, whereas a criminal prosecutor, you got someone's entire criminal history. And so it was very shocking to me, and school districts were relying on this letter and not really realizing that there's a lot of information potentially in someone's criminal history. And what I mean by that is there are a lot of different dispositions. You can be arrested for something and have it be placed on file or pending, or in Massachusetts they do a conviction without a finding, and I still don't know what that is. But there's all these different variations on a theme, if you will. And what happened, sadly, is that we had a case out in the western part of the state where an individual was charged with really severe sex offenses against a child. And for whatever reason, those charges were reduced down, pled out, and I can't speak to the reason behind it. And when that person applied for a job in a school, they were subject to the criminal background check, just like everyone else, pursuant to that law. And the Department of Safety, pursuant to the law at the time, released a letter that said the person did not have any Section 5 violations because they didn't. The offenses had been pled down. And that victim was brave enough, so he was employed in the school and reoffended. That victim was brave enough to come before this committee, this House, and testify to her experience. And it was this legislative body that changed the law to allow for the release of all offenses. And now you'll see misdemeanors and felonies, which is why Section 5 says that each school district can create a policy which allows them to take into consideration offenses that fall outside the Section 5 violations. Last legislative session, or it might have been the one before, I got to be honest with you, the two kind of blend together due to the pandemic, so I don't know which year it was, but most recently, the law was amended again to allow for the complete release, which goes beyond just convictions. So you will see things that were null pros, which means the state dismissed the charges. And so school districts are now receiving the entire record. People can debate whether that is good or bad. I will always say, and I've said it before, when you're dealing with children, it's good to have all the information so you can make a well-informed choice. We are not hiring people to put widgets in a box. We're hiring people to be around children, so the more information, the better. And I will give significant credit to Representative Mullen, who passed a law that requires the Department of Ed to do trainings for districts on criminal histories, and we have been doing that throughout the state on a routine basis. And every time I do one, I call Representative Mullen and say, law in action, I just did your training. So we have been out doing those with the Department of Safety, and we've been getting a lot of requests on that to provide that information. So it's, again, a nice partnership with the department and the districts to say, we live in a new world now, right? We can't rely on a letter that says no Section 5 violation, or yes there is, no there isn't. We have to have this information. We recognize how critically important it is. And the department recognizes how critically important it is, and we put that emphasis into all these various programs that we're doing and these initiatives that are going forward. You asked about liability. There's criminal liability and there's civil liability. And there's a significant difference between the two. I'm not really here to opine on it, but is it a possibility of a lawsuit? Yes, lawsuits are possible. I don't know how much deeper I can go on that, and I don't mean to be flip or disrespectful, but it is a pretty broad topic and perhaps worthy of a conversation offline, but I appreciate the opportunity for the question. Thank you.
Thank you very much. Are there further questions? I want to, sort of like slow down these questions, we're overlapping the other, and this is technical support. We can get that for the committee even after this particular hearing. Representative Mullen.
Thank you, Mr. Chair, and thank you, Attorney Fenton. You referenced in conversation this morning that you and the commissioner always talk about student safety whenever new programs are coming online. Has a conversation taken place between you and the commissioner regarding educational service providers in the EFA program? And if so, are there going to be rules written, or what would
what's the department recommending in terms of the process for checking out the backgrounds of the ESPs?
Sure, and I'm going to put the details of that into the same bucket I did with Representative Luno. I can get back to you with those details, but the short answer is yes. In every initiative we undertake, we always have that conversation, and that is always paramount. And what it looks like in every program might vary a little bit, but it's always going to come back to that same law that we've been discussing. That is our guiding principle, and it's just a question of how we apply it.
Thank you. Good.
Thank you.
And do we need to put something into law? Do we need to codify 189A as part of the EFA program to be sure that people that are employed as vendors or providers or contractors, whatever we want to call them, meet the requirements of 189A?
I think whether or not it's codified in the statute is really beyond my pay grade, regardless of what title this committee continues to give me at various times. But that's what the rulemaking is for, and that's what we've seen in the Learn Everywhere program. So there are avenues by which the department can and does successfully implement the reference to the statute. Whether or not this committee wants to codify it in the statute is within your purview to do so. But just because it's not codified in the statute doesn't mean it's not implemented. It can be implemented in other ways via the rulemaking process. And we've seen that throughout.
And we have seen that in relation to another bill which we've been dealing with this year is, do we put something in statute or do we work through rule? And that's a good question. It has a lot of detail we have to look at, because at times it's wiser to work through rule. Rule can be changed quicker than statute can be. And so there's a lot more to it, and we discussed that in terms of one other area, which we involved several folks on earlier, not more than a week and a half, 2 weeks ago. So further questions on this? Representative Likas.
Yes, I have two questions. One is, I remember when we tried to do this before, and as you've said, a lot of things have changed since then. And I'm wondering, did anything ever change or happen at the department concerning like tutors who might teach lots of different places? Does the department now have a way for them to, you know, like a list or whatever, a way for them to do one background check that the department has, or would we still have to do a background check every time we have a new student?
So currently, that particular scenario would be dealt with as an employment matter. That would not be something that falls within the jurisdiction of the Department of Education. Our authority is enumerated quite clearly in 189.13b and 13c, and it does not, at this time, involve tutors.
Okay. And the other one is, just from a legal perspective, I don't really understand Section 1 and who exactly, I mean, any employee or volunteer of an entity contracted for educational services by the department. It's like, exactly who all does that talk about?
Well, I will reference the previous testimony I gave as it pertained to the fiscal note. In answering the fiscal note, in writing the fiscal note, I grappled with the piece that this language that you refer to, and I will refer to as well, lines 3 through 6, I found to be overly broad, and I wasn't sure I wasn't sure how to quantify it and how to address it. And that's why we put down that it was indeterminable, because I felt that this could be it could be read a variety of ways, and it was very very large. That pool was very large, potentially, depending on your interpretation.
Thank you.
Thank you very much. Representative Woodcock.
Yes,
and
Representative.
Wells.
Well, thank you. Attorney Fenton, I just want to thank you for coming forward and answering my questions.
You're very welcome.
Okay, Representative Waltz.
So I'm not as familiar with this as other members of the committee, given my temporary status. But what I think I'm hearing you say is at least part of this bill codifies stuff that's already in the rules. Am I hearing that correctly?
Yes.
And which part?
I would have to look at the EFA rules, and then we can puzzle it out from there.
Okay, that's fair.
And
Thank
I'm
you.
happy to get back to you on that. But again, all the programs that we do, we incorporate the criminal history reference check. So yes, we can pull those sections of the rule and line them up and see which ones are redundant or already incorporated. But yes, the short answer to your question is it's incorporated already.
Follow up?
Yes.
But even if they're already in rules, there is a reason to codify this as well. I mean, there's a reason we codify things beyond what's in the rules. So just because they're in the rules doesn't mean this shouldn't be passed necessarily. Wouldn't you agree that there could be additional implications if we codify this?
Two lawyers battle it out in the ring. If I didn't know you were a lawyer before, I'd know now.
I'll withdraw the question.
I think that this legislative body will have its reasons to codify it in the statute. Whether or not I agree with that is irrelevant. But yes, it would have certain implications if you were to codify it in the law.
Thank you.
Thank you.
That discussion can go on forever.
And
Really.
I'm married to a lawyer, so it's just.
Oh,
you
it
know,
must be fun at breakfast and lunch and dinner.
Right.
So am I, and believe me, the first grade teachers all said,
Okay,
"We know your
I
kids
think
have
what we're
two
going to do,
lawyers."
this bill right here is not an early bill. We have to have it out of this committee by March 10th. So there's a little bit of time there's been a lot of questions asked here. And it might be wise for us to just consider a committee of the whole subcommittee work session somewhere along the way here, and give some time for the department to come back with some of the responses to what we've asked, and then we can have further discussion at that particular moment. So rather than having more questions to you right now, Attorney Fenton, Colonel Fenton, Governor Fenton.
I would also suggest that we involve our partners at the Department of Safety because they have been really critical in this.
I think it'd be wise. Thank you.
Thank you.
We'll try and set something like that up and working with you. So with that, we have no more pink cards on this particular bill, so we're going to close this hearing. And we'll move into the next bill, which is on the docket. That is 1402. 1402, in relation to inclusion of charter public schools in school district bond issuance votes. Good morning. And so with that, I'd like to welcome Representative Mooney, who is the prime sponsor of the bill.
Thank you. Good morning, Mr. Chairman, Mr. Vice Chairman, members of the committee. For the record, my name is Maureen Mooney, a state representative from the town of Merrimack, Hillsborough County, District Number 21. I'm the prime sponsor of House Bill 1402, and in support of it, the title is an act relative to inclusion of chartered public schools in school district bond issuances. I have, for convenience, given my testimony in written form to the clerk, who I believe has distributed to all of you, in an attempt to very carefully go through the bill to give you an overview. The intention of the bill is to allow chartered schools participation in the bond process, as well as open the lines of communication further between school districts and public chartered schools. This can be done within this bill as follows. placed in the Municipal Finance Act, which is found in RSA 33:1 through 33:20. Number one, and this is again the process, taking you through the process in this bill of how this would work. School districts considering submitting questions of authorizing bonded indebtedness shall invite chartered public schools to participate in discussions and are encouraged, key word there, to voluntarily include funding for capital construction needs of chartered public schools in the district's question of authorizing bonded indebtedness. This is side note, away from my script here. This is probably the most important point of the bill, is that the school district offer the invitation to the public chartered school in their town or city to be part of the discussion if a bond question will go on the ballot. Key point there to open lines of communication. Number two, if the chartered public school has construction needs, it may request that the local school board include it as part of a ballot question for approval of bonded indebtedness for the voters. And the chartered public school, in that conversation with the school district that has construction needs, must submit a detailed capital construction plan to the school district board that includes specified items. Those specified items are in sections 1 through 8 in the bill, section Roman 2, small c. The school board now shall notify the chartered public school in writing whether it has accepted or not the capital construction needs for inclusion in the ballot question. This gives the school board the authority to accept or reject the chartered school's request. Then I break it down into two scenarios, my items 4 and 5 in the written testimony. Scenario 1, if the school district accepts the chartered school's needs, the chartered public school capital construction needs shall be included in the same ballot questions submitted by the district. In scenario 2, if not accepted, the school board says no to the chartered public school construction needs, then the chartered public school has an opportunity to address any issues provided in writing by the school board. That's where it ends in this bill. Additionally, the bill allows for alternative financial plans whereby school districts and chartered public schools may agree to an alternative financial plan addressing facility needs for benefit of chartered public schools. Such plans could include, and this is text taken from the bill, retiring financial obligations previously issued for the benefit of the chartered public school. The final section of the bill, so that is section 2, amends the chartered public school reference to the process of bond issue. This is the same section stating that the state is not liable for any debt or other obligation. Now for my concluding remarks. The bill strengthens communication between school districts and chartered public schools. Again, I bring you back to number 1 in my testimony. Here the conversation begins. The school district and the chartered public school within the district are in conversation about building and construction needs. Chartered public schools are public schools. They have needs just like traditional public schools, for lack of a phrase. That includes construction costs. This bill would bring them into the discussion. This bill also provides options for funding capital construction costs for chartered schools, being part of a bond process if the school board determines it's good. And lastly, this bill will clarify whether or not chartered public schools are even allowed to participate in the bond process, because that is unclear in current law. And with that, I want to thank you for your attention. I want to thank you for your service to our state. I believe this will be the last bill I'll introduce in this committee this year. And I want to thank you again, Mr. Chairman.
You're welcome. Are there questions from the committee? Yes, Representative Walz.
So Representative Mooney, if I'm understanding this, you're asking a local school district to take on responsibility for a bond for a school over which it has no authority? Am I correct?
Thank you for the question. I would say not necessarily, no. Because in the discussions would be, and if the school board were to accept the plan, there would be further discussion as to how the question will be phrased, how it will appear in the voter guide, who the bondholder will be, and the like. So in sum, to answer your question, no, not necessarily.
Follow up?
Yes.
But I don't understand how that financing information has any relationship to whether the school board or the school district has any control over that charter school. That charter school is an independent institution. So you're asking a community to take on the financial responsibility for an independent institution, which is going to be independent in the way it's run, who it hires, what the principal is, what their policies are, independent of the school district and the school board, yet the town would, despite the fact they don't have control over the way the school is run, would then be financially responsible. That's my understanding of this. Help me if I'm wrong.
Thank you for that. And I can't see where every conversation, every discussion that the chartered public school is invited to from the public school board would result in the scenario you painted. So I believe that they would continue, the chartered school would be able to continue its autonomy, but there would be discussions, extensive discussions on how this would work, but at least the door here is opened. I don't see that scenario you painted coming to light in every conversation between the chartered school and the school board.
Are there further questions? Representative Luno.
So thank you very much. And and I think, Representative Mooney, that that we need to be completely transparent with the citizens in New Hampshire when it comes to bills like this, and that we can't sort of say, well, not necessarily, or really, I'm not really sure if it would go that way. I think we need to be completely clear. So I'd like you to explain how the word shall on line 11 doesn't actually commit the voters in a school district to assuming the financial costs associated with a bond for a private institution.
Thank you for that question. So that shall appears in my number 1 in my testimony. Shall invite. It does not say shall commit to the debt of the charter school, shall have their question be included in the school district's question in the upcoming election. It doesn't say that. It says shall invite to the discussion. Participate in discussions. Then you go through the rest of the sections here. I tried to summarize it and describe it. Would be then the process of what happens, keeping the school board basically in control. After those discussions, if the school board says no to the construction plan, you can't be on our ballot question, the answer is no. And I agree with your point about transparency, absolutely. But I also agree that chartered public schools, like other public schools, have the same needs, and that includes costs of and updates and so on related to facilities. So I guess in sum, I don't see where shall takes on anything other than, continuing with the rest of the sentence, participate in discussions regarding the possible, another emphasis, possible submission of such a question. There is no commitment in section Roman 2A, other than, hey, we're having a discussion on a bond, why don't you send the representative?
Representative Woodcock.
Thank you, Chairman Ladd. Thank you, Representative Lee, for taking my question. I enjoy watching you perform. My question specifically deals with the building piece, and usually Representative Ladd or Luno have, no, not usually, always have much better understanding of that than I. But in this case, if I was a charter public school in District X, and I receive students from hither and thither to the enrollment, how would the other sending hither and thither schools be responsible or pay their share of this building process? Because in my thinking, I may be incorrect, but I thought typically that'd be the bonding for that town or school district. So how does the other participating districts pay their share of that bonding under this scenario?
Yeah, it's a good question, and the answer is they don't. It is on the town or the city where the school district is located. So unless future legislation would have a money follows the child sort of scenario, the answer to your question is they don't, as far as I see in this bill.
Thank you. So I'm perfectly clear on this. My town is going to pay, with no chance for reimbursement under this bill, for students from other sending towns that are paying no cost to that, unlike a cooperative school or a regional school. They're just coming in and they're free, basically, to the town.
Yes, however, in your question, you mentioned, and thank you for the follow-up, you mentioned a scenario that taking on the indebtedness, that doesn't necessarily, based on the discussions that could be had between the charter school and the school district, they might be able to figure something out beyond, say you're a charter school in Manchester and you're dealing with Manchester School Board. Manchester, you're going to take on all of our construction needs. So, yes.
Thank you, Representative White. Appreciate it.
Representative Moffett.
Thank you, Mr. Chair, and thank you for being here. So my question has to do with, if you can cast your mind back to last year, 2021, we passed HB 278, I think it was, and that passed this committee, passed the House, passed Senate, governor signed it into law, and that was the bill that gave charters first dibs, if that's the right way to put it, on unused or available vacant, whatever, public school properties. So my question is that if that bill, which is now law, codified already a special relationship between districts and charters, does that bill have a relationship to what you're trying to move forward here?
Thank you for the question. I do recall the bill. I gave the parliamentary inquiry on the bill, and it won by 5 votes through the House. It is certainly a help. It is certainly a plus, but this bill would open that door even wider. In fact, in consultation with those who will testify after me, that bill has come up several times, and it's in agreement that everyone is very much in favor of that bill and looking forward to it, and it does open lines, but this would open lines further in terms of construction costs and building needs.
Thank you.
Representative Ellison, then Representative Ford.
Thank you, Mr. Chair. And thank you, Representative, for taking my question.
Oh, sorry.
I put myself in
I thought you were over here.
way down the list behind Representatives Ladd, Luno, and Woodcock in terms of understanding of how this works. But a question I have will be on page 3, lines 15 through 21, which deal with a charter school, public charter school becoming insolvent. And then it talks about that the charter school shall repay to the district at a rate of 5%. If a school is insolvent and in fact doesn't have resources, how are they going to repay the bond to the school district if they don't have the resources to do that?
That's a good question, and I'm glad you brought up that section because I didn't mention it in my testimony, but it's an important section, and that's the wrap-up if, in fact, there's a school that is in the situation you described. I would refer you to line 14, where it mentions that if, in fact, the chartered school goes forward with a bond question and the like, they will enter into a contract with the school district where the charter school is located that would spell out exactly scenarios and terms as you described. As for the specifics of that, I cannot get into that. I don't know the answer. But I would imagine that in that section, entering into a contract like that, various chartered schools, various school boards, a scenario like that would be included and accounted for.
Follow-up? Yes. Given that scenario, then I would assume there would be, in that agreement, there would be some answer to the question that I asked, which is the charter school is insolvent, does not have resources, and therefore we're not going to repay the school. And everybody's going to agree to that?
I would. Is that your question?
Yes.
I agree with that.
Thank you.
Yes, I do. I think exactly what that contract will do.
Representative Ford.
Thank you, Mr. Chair, and thank you for entertaining my question. I asked a question in a similar discussion some time ago about who owns the property. I think I should have rephrased it at that time, and I'm asking you, wouldn't this be clarified if this stated that whoever provides the funding shall hold a lien on the property from the get-go? And so you don't pay it back, we own the property. And that's the person who paid out the money, and that in this case, it would be the school board or the town or whatever. But wouldn't that simplify this process?
Thank you for the question. I remember the question from last week. I would agree with that. Yes, I think that would be a friendly amendment. And in addition, any sort of clarification as to ownership and the like, which what you're proposing would do, I think would be an asset to the bill.
There are a lot of questions on this.
I understand, and I would, too, remind the committee that there are those speaking after me. And perhaps if there are questions that they can't answer or better directed to me, I'd be happy to come at the end again. But I understand the specifics of this, and I would ask that others behind me also have things to contribute.
One more question to the person testifying right now. Representative Lakes.
Yes, you're talking about if school boards have a bond, are already thinking of a bond issue. And my question is, can the charter school come if the school board doesn't have a bond issue on their regular, where they're doing contracts and all of that? Can the charter school still ask if there can be a bond put on?
Thank you for that. And that's very important, and that was related to my concluding remarks. It's unclear. I would say the law is unclear on that very point. I don't know the scenario playing out if a chartered school were to approach the school board and ask how the school board would receive that, but this bill would hopefully clarify that, or an amendment that would even say that would be very beneficial, because right now it is unclear, and that's the best I can answer that question. Thank you for that, though. Very important.
Thank you.
Okay, thank you very much for your presentation. We'll go on to the next speaker right now, Bill Phillips.
I'm Bill Phillips with the National Alliance for Public Charter Schools. Thank you once again for having me. I was actually doing just fine with the way you were going there, peppering her with those questions. I was writing them down frantically, but And I can answer, there's a couple there that I can help answer. But from a testimony standpoint, let me, you have my testimony, so let me just speak broadly to a little bit of it. The rationale for the bill is twofold, and I talked a little bit about this last week, in that you have a situation in New Hampshire now where your charter schools, for the most part, are using they're using funds that should go for programming for their facilities. And I actually, for what it's worth, in the 2 pages, the back page I gave you, forgive the presentation on it, but on the right side of it, there was a survey done in 2018 that surveyed the charter schools, and it identified a number of ways of which they were having programming issues due to funding issues. So my point is that once they're up and growing, there's a need for help with their facilities so that they can actually implement their programming and not have to use their operating funds for facilities. Their programming funds for facilities, if you will. The other reason for this, which was not stated, but which we have seen in a couple other states, I don't think I have to tell you that school bonds are hard to pass, including the charter interests in the bonding process. I think actually may make it easier to pass the bond at some point. I mean, that's actually what you'll see in other places. I mean, look, I live in a place where I don't remember a bond ever passing by more than 3, 4, 5%. And you're going to get to some places where the charter community is going to be 3, 4, 5%. I think you might want them energized and involved in your bonding process. And so this actually, one of the things that Representative Mooney mentioned, we actually checked the Municipal Finance Act. It is not clear on this. It is not clear that the charters and the districts can work together on bonding. It is not at all clear that they can do their own bonding. If I may answer your question, the way the law is currently written, I don't think the charter could. So the law right now is not clear at all. If we pass this bill, I don't think it's clear that the charter could do it on its own as well. And honestly, I'm not sure how they would actually pass a bond. They're still a pretty small part of the population. I wouldn't be against that amendment, but I think the reason this would work is when you start to get the district interest and the charter interest on the same page. So, okay, so I want to, in very broad terms, explain what we're trying to do here. The district's considering bonding. They're obligated to notify the charter of its intentions. The charter has the right to request participation in the bonding effort. The district has the right to say no. Okay, very, very clear. This is voluntary on behalf of the district. Okay. I will answer, there were a number of questions that were asked that were related to why would this make sense. I think you shouldn't lose sight of the fact that, remember, the taxpayers actually get to say no. So for instance, if Representative Ellison, you asked a bunch of questions as to, like, why would they do this? If they don't give a good answer, you know what? They're going to lose the bond fight. Don't forget, the taxpayer gets to say no, even if the district says yes. Last point here, and then I'm actually just, if you'll let me, I'll run through some of the questions that were asked earlier. I want to flag for you, in the past month, Representative Mooney, we've presented three different kinds of facilities bills. We did a revolving fund, we did building aid last week, and now we've got this bonding bill here. Context behind that is you have a state, I realize this is not 100% of the state feeling that way, but you have a state now that is interested in growing the charter space. The things that get in the way of that are lack of startup funds, facilities problems, and access to talent. You dealt with the startup issue when you accepted the federal CSP grant, which I realize was a little bit dramatic for a while, but you dealt with it. This is about dealing with the facilities issue. The other piece, if you looked at that second page, I had flagged for you that there's a fairly decent sized gap between district and charter funding. Let me tell you what I'm not saying with that, is I'm not saying, oh, you got to even that up or you don't care about kids. I am not saying that. I don't know what the right number is, frankly. What I'm actually telling you is when I look at a lot of states and when I see that kind of a gap, it doesn't surprise me that the charters are just having a hard time getting their buildings paid for. So what we're trying to do is just give you some solutions to actually help fix that problem. The lease aid work you did last year, the disposition, the 278, Representative Mott, the bill you were talking about for that, those are all great steps. They all help solve the problem. This just helps it a bit more. And that's the context that I would hope you'd consider this with. Mr. Chairman, before I take questions, do you mind if I answer a couple of the questions that were asked? Or I can do either way.
Well, we are on a tightrope here. We did get some responses from the representative who presented the bill. If you can go over that in a minute or two, that'd be fine, but I don't want to get into a lengthy discussion on that at this point in time.
Yep, okay. How about this? There was one piece that I would want to clarify. There was Representative Ford, you asked a question about who owns the building. You could do it by an amendment, or the other thing you could do, charters typically enter into what are known as dissolution agreements with the state. So you could actually write that into the dissolution statement, where the way it could be the town owns the building, or it could be, in the case of dissolution, the charter is obligated to sell the building and pay off the bondholders and the taxpayers. You can do it either way. The dissolution agreement just might give you, maybe what you want to make sure you have an amendment on is making sure there is a dissolution agreement. That way it would be the most flexible way that they could actually write it to fit local circumstances.
Thank you. Are there questions from the committee? Not seeing any. Thank you very much.
It's a pleasure. Thank you again for having me.
Invite Kimberly Lavelle.
Good morning, Mr. Chairman and committee members. My name is Kim Lavelle. I reside in Mount Vernon, and I am here in support of HB 1402. I recognize your time is tight, so I'll just go over some of the highlights. I think clearing up the law in this matter would be a great step forward, as Representative Mooney has said. Encouraging collaboration between districts and charter schools is another great step forward in opening that door. It's only going to benefit the students. One of the ways, I think it's very rare, but one way that this may benefit the districts is if you have a district with a number of charter schools in that district and they're applying for the bond, they put it forward, they may gain additional support if they're able to accept some of the smaller construction needs that perhaps the charter schools are putting forward as well. You have a lot of charter school parents in those districts who would be voting. That may be another option. The point about funding going towards facility instead of programming, I can speak to that. Having worked in a charter school and opened several and working with a number of them out there, it's such an issue. 7338, that's what they're given, and trying to find funding for any improvement, much less purchasing a building, is incredibly hard. Typically it comes from donations, or you have to take it away from something else that's happening in the school, which is necessary for the kiddos. So that's my testimony. Thank you so much. If you have any questions, I'm happy to answer them.
Thank you very much. Are there questions? Representative Moffett.
Thank you, Ms. Chair. Thank you for being here. So I'll preface my question with a quick description of, I'm from Groveton, and Groveton has a Catholic hall that had classrooms in it. And for a period of time, the district, the public school district, used in some fashion, rented the space in the Catholic hall for, in kindergarten and first graders were educated there. In fact, Dr. Carl Ladd, who often comes here, went to school in that Catholic, for a while in that Catholic building. So my question is, with regard to potential mutual use of a potential structure that may be built, and I know you're in the charter school world, so my question is, if this were to move forward, do we need to look at this as mutually exclusive in terms of use of these school buildings, or could both a public district and a charter district use the same space out of this?
If I understand your question correctly, it would be looking at the space that has been funded by a bond from one of these schools or from both coming forward to be used for both entities. I don't think that would be a problem, but I would really prefer to have Mr. Phillips or Representative Mooney answer that.
Follow-up? Thank you. So, to your knowledge, you can't cite any existing scenarios or models that are out there where space is shared between public schools and public charter schools. You don't have any examples of that?
I don't have any off the top of my head where they're sharing the actual building. I believe we have a few, one or two maybe, I don't have the exact number, of charter schools that may be in a public school building as a result of HB 278 perhaps renting space. But the only case that I can think of would be, I think it's a little different, it would be a charter school that rents space from a community college.
Oh, okay, thank you.
Further questions? Not seeing any. Thank you very much.
Thank you very much.
And our last pink card on that, this one is Bob Best.
Thank you, Mr. Chair, and members of the committee for the opportunity to be here. My name is Bob Best. I'm from Merrimack. I support HB 1402. I'm an attorney with Soloway and Hollis and provide legal advice to a number of charter schools and also legal advice or been involved with a number of the bond issues through the state's 3 bonding authorities. I don't know a lot about municipal bonding. I won't talk a lot about that, but a little bit about some other types of bonds that are issued where there may be some parallels and some opportunities. But first, start with the importance to charter schools of this. New Hampshire has, long had its statute that created charter schools and supports them and creates some funding for them for their operations. The $7,300 that come per student, helps to pay the salaries for the teachers and administrators and books and computers and things. And then there's the federal grants for the startup programs, and obviously that helps out a lot, but those federal grants don't provide any aid for the buildings. They're not allowed to be used for capital expenses. So you're certainly left with this question: if you're going to operate a charter school, where do you get the building? Where does it come from? And for the sake of size or scope, a school building that would have a 300 student capacity is probably something like a $3 to $5 million building. And that funding's got to come from somewhere. Traditionally, it's been leased. I think we heard last week that there's some 1 or 2 or 3 charter schools that actually own their buildings. And so you lease quite a lot of them. But obviously, renting from somebody else is not as efficient a way to deal with it as to actually own the building and build it and construct it. So bond funding is one avenue to do that. The building aid that we talked about last week is an avenue to do that. And there's some other opportunities. When it comes to the bond funding and this idea of creating a dialogue with the school district and allowing them the option to include it or not, that doesn't in any way obligate the school district to say, we will pay your bonds for you or we'll pay them back for you. You can be included in a bond issue and have an agreement that says the charter school pays back the bonds that it seeks. You can have an agreement that says, agreement with the bond buyer that says that X part of these bonds or the Series B piece of the bonds are only payable from revenues of the charter school. Very common in the HEFA bonds and other state authority bonds that are issued. These are not grants from taxpayer money. These are loans from some bond buyer, and they get paid back. And it's up to the school district and the charter school to figure out what are the terms between them that the school district finds acceptable that might make the school district willing to say, yes, you can be a part of my effort. And if the school district isn't satisfied with those terms, as you've heard from other testimony, they can certainly say no. But those terms can certainly obligate the charter school. It could mortgage the charter school's building to pay for or answer for the bonds. It obviously has to land in a place where somebody wants to buy the bonds at the interest rate that they pay, and that depends on creditworthiness and security and all of the kinds of questions that normal loans are, sort of house mortgages. Bonds are complicated forms, but they're just mortgages, they're just loans. And creditworthiness is what bond buyers consider. And all of those kinds of things can be tackled. There's no circumstance where any school district would be obligated against their will to take on somebody else's responsibility. I think that the bill certainly allows the school district to do that, but I don't think anyone really has any practical belief that a school district's going to say, yes, I'll borrow money for you and we'll pay it back. You don't have to. I don't think that's the dialogue anybody expects. So there's certainly that opportunity for the protections that everybody's talking about. Who owns the building? How does this get paid back? How's the school district not at risk? How are the taxpayers not at risk? All of those things can be solved. They're solved every day in the bonds that are issued by the three state-run bonding authorities. And then as to whether there's an opportunity to share a building or the Senate bill, House Bill 278, I think is the number from last year that gave the districts the first dibs on the buildings. That's the first dib to buy it or rent it. It doesn't mean that the charter school gets the leftover building for free. But even if they did, and they had a building that was available that a school district didn't want anymore, that building probably is in need of some things, which is probably why the school district decided they didn't want to use that building anymore. So it may be that even if you were able to get access to a building through that bill, you need to do a bond issue or a loan or something to modernize the building, to bring it up to code, to install sort of all of the internet features. And now with COVID, you're dealing with the HVAC and all of the ionic whatever that's in the air vents to make sure you're killing all of the viruses that go through the air vents, and security and all the needs for that. You might have a building that you even acquired for free that needs $1 million worth of upgrades just because of the fact that it was a tired building that the school district was ready to pass along. You could still be in a position where you need both the benefit of 278 and some other avenue to make use of a building like that. I don't think that there's any reason why schools and charter schools couldn't share space if they chose to. I think that there are a couple of charter schools that are actually district-sponsored charter schools. I don't know all the details of that, so I don't want to necessarily go down that rabbit hole and try to answer questions about how that works. But I think that obviously if they're a district-sponsored school, the district's got ownership of the charter school's property already. So those kinds of those solutions have already been established. Two messages. Very important for charter schools to have a source of funding for buildings. Without buildings, we're just not going to have the kind of proliferation of charter schools. Right now, there's a handful of very generous donors who support the provision of buildings to charter schools. But as we've talked about many times, relying on the generosity of a handful of people who are able to do so isn't a way to finance a public school offering. Second message is, as to all the mechanics and the logistics that people are concerned about, all of those things can be worked out, and all of those things can be worked out in a way where the school district, first of all, has complete discretion on what to do and complete protection so that they're not at risk or that they're not required to tax their citizens to pay back a charter school's bonds. Glad to answer any questions anybody has.
Yes, I have a question for, I guess, you and others that have testified today. We have in the state what we call a school building authority. And the school building authority, as I read it, upon the receipt of a report from the authority containing a recommendation that bonds or notes of a school district should be guaranteed by the state. Why is it that this legislation is trying to drive these bonds through the school district rather than the state, which has authority to issue bonds up to not to exceed $95 million?
I don't know the ins and outs of exactly the way the state deals with its bonding directly, where the state is responsible for the bonds or even where the school districts are. My experience with those is that the three bonding authorities where the state is explicitly not obligated on the bonds. And that's why I bring that message as to how that could be the case with charter schools. As far as how it works, where there's some recommendation of a committee that the state support that funding, I honestly don't know enough about that to offer any comment that's useful.
Thank you. Questions, Representative Waltz?
Thank you. So you said that you know a lot about the bonding market. Given the lack of resources that these charter schools have, and given that they're not guaranteed by a state or a city, wouldn't the market just consider these junk bonds?
So whether the market would do that or not, or whether the market would even buy the bonds, when there's a bond offering through one of the bonding authorities at the state, the buyer is sort of identified, buyer of those bonds, and the rates and the terms and all of that are lined up by the borrower before they're even brought to the authority. So we know that Citizens Bank is going to buy all of the bonds for a particular issue, or you name the bank. And if the borrower can't find a bank or a lender that's willing to offer and buy those bonds, the authority, nothing happens. The bonds could be issued, but nobody's going to purchase them, and nobody got any money. And essentially the deal doesn't obligate anybody to anything, because it's like applying for a car loan and then getting turned down. You don't have a loan.
Follow up?
Go ahead.
So I don't understand how you're saying that it's all lined up ahead of time. We're in the bond market all the time buying bonds, and you buy municipal bonds, you can buy all kinds of bonds issued by governmental entities. What do you mean that they would be only go to market if they're picked up by a bank? Of course there's other kinds of bonds out there that aren't picked up by a bank, but they are issued by governmental authorities.
Sure. There are obviously private placement and public placement bonds. I didn't mean to misspeak about that. The public placement bonds, the public offerings of bonds are done through a bond trustee who is doing that same level of evaluation about the quality of the bonds and are they rated, and Moody's and all of that kind of thing. And ultimately, if somebody doesn't buy the bonds because they believe that they're rated wrong or that they're high risk or something like that, again, it's just a loan that didn't go through.
Representative Porter?
Thank you, Mr. Chair. And just very quickly, my understanding, if this went through and the charter was responsible for paying back the bond, you talked about credit rating. If the charter defaulted on the bond, would that negatively impact the credit rating of the school for future bonds, the school district for future bonds? Just a simple yes or no is all I need.
It's a great question, and I think it depends. I know that you want yes or no. If the school district and the charter school arrange some of that financing the way that it's done on a state level, it would not affect the state's credit rating, which is similar to the bonds that are offered through Business Finance Authority and the Housing Finance Authority. They don't affect the state of New Hampshire's credit rating.
No, I was talking about the school district's credit rating.
Sure, and that's what I mean, is that within the documents of the way the bond issue is done, there's ways to arrange it so that it doesn't affect the school district's credit rating. But whether the school district and the charter school would do all of those things is up to them to achieve.
Thank you. Are there further questions from the committee? Not seeing any hands. Thank you.
Thank you very much, Mr. Chair, and thank you very much, Attorney Best. I'm trying to find the answer to this, but it's not jumping out at me. But was wondering if in towns that have adopted the official ballot law SB2, if bond articles can be changed at deliberative sessions.
Oh boy, you're way out of my scope of skills
Okay.
there.
No, that's
I wish
all
I
right.
knew the answer. I don't.
All right, no worries. Thanks.
Thank you. Further questions? Not seeing. Thank you very much. Not having any further cards in this one, we will close this hearing, and we'll start the next hearing up in about 5 minutes. Okay, we're ready to go ahead with the next bill, and the next bill is 1605, requiring SAUs to maintain a report on the 5-year projection of future enrollments. And is Griffin, Petrie, Emmerich, the Burge here? Do we have any people signed up to speak on that one? Honorable Mr. Craig, Bob, are you here to speak on this one? Okay, thank you. Yeah, I don't see any cards, so quickly introduce it, and then we'll close it down.
Thank you, Mr. Chairman, members of the Education Committee. Since the prime sponsor is not here, I'm introducing House Bill 1605. This bill requires school administrative units to annually report to school districts the 5-year projection of future enrollments within a school administration unit, including cost per student information. The requirement was repealed in 2025. So, thank you, and I will not take questions.
Thank you very much, Representative. Well,
One quick one
we
of
do
the
have somebody-
representative from Litchfield. Does the Litchfield district already do this?
I'm not sure. I'll find out Saturday when we have a deliberative session.
Okay. I'd be surprised if they're not maintaining a projection. So thanks.
Okay, we have one speaker on that. We have Becky Wilson from the New Hampshire School Boards Association. Speaking in opposition to the bill.
Good morning, Chairman Ladden, members of the committee. Thanks for hearing my testimony today. I will be expedient because I know you have quite a few people for the next hearing. I did submit some comments in writing already to the committee around this bill. We are in opposition of this bill. We feel like that school boards already do an extraordinary job and take extraordinary care to try to be mindful of the impacts not only on the students when they're developing the budget, but on the local taxpayers in their community. There are multiple opportunities for community members to engage in the budget development process and to adjust the operating budget of the school as they go through these budget processes each year. The inflation rate annually is not published until January of the following year. Most of your school district's budgets have been worked on since October at that point. To require districts to have to make cuts or develop a plan somehow to reduce the operating budget that the town has already had multiple opportunities to weigh in on seems like a very large burden that would create a lot of discourse with the school districts in terms of trying to cut programs that have already been budgeted for the following year. I will not read my entire testimony, but on top of that, this bill also seems to require that if you were going to present a budget to the town for a vote or at deliberative session that was had a higher rate than the current inflation rate, that you would have to then present this plan for cuts and or for consolidation. And there's been other bills before this committee to dissolve consolidations, so it seems a little confusing, quite honestly, to expect districts to be able to do that. And enrollment is not the only driver of a school district budget. It is an important driver, and most districts do maintain, to the best of their ability, some sort of enrollment trends that they can look at when they're creating these budgets. That's why sometimes there's 5 second grades one year and 3 the following year. But there are a number of options now for families in terms of how to educate their children in this state. And it creates some difficulty when you're trying as a school district to predict your enrollment. There's no notification requirement for the school district to be told if students are moving into a homeschool situation or an EFA situation. There are no guardrails in terms of districts being able to predict which students will enter the school district, even using the town report, which I know a lot of districts do that, to look at the number of live births for a given year and try to predict when those students will enter the system. So with that, I'm happy to take any questions.
Thank you very much. Are there questions for Becky Wilson from the School Boards Association? Not seeing any. Thank you very much.
Thank you.
Okay, that closes this hearing. The next bill on the docket for today is HB 1663, relative to requirements for home education students. Let's see who's. Yeah, I know it. Yeah. Yeah, okay. We need to have a representative in here with a pink card to present this bill. I have not seen an amendment. In fact, there is no amendment that's a committee amendment until it's presented by a committee member. So a lot of people can draw up amendments. I'm not interested in that. I'm interested only in the bill as it's introduced. I have not seen it. Okay, thank you. Just to have some guidelines for how we're going to conduct ourselves today. I don't want to have a lot of duplication in what you're saying. You know, if we are, we're going to have to get down to time limits, and it might even get down to like a minute a person. So that if everybody has a story. I understand that we appreciate the story, but if the story is on the same vein, don't give it if it's already been given. So please follow the rules, or else we will immediately put in time constraints. And in some committees where that's occurred, the hearing is stopped. So please respect what I'm saying. Go ahead, and I'd like to welcome Representative Leon here for introducing this bill. Thank you.
Good morning. Thank you for having me here today. For the record, I am Erica Leon, representing Rockingham 6, which is Derry. I come before you today in order to address ambiguities and difficulties in the current home education law. They have impacted our communities, and in particular, families that are struggling to find a safe and nurturing education for their children during these last 2 years of COVID. These changes don't impact the taxpayers, and the guidance provided to schools and their interactions with homeschoolers is focused on equity. However, the greatest impact on equity is in a change to the annual assessment language to be more inclusive of our large and growing special education homeschooling community and those with learning loss before they chose to educate at home under RSA 193A. Section 1 addresses equal access, which has been proven to be a significant challenge, one that others here, such as Amanda Whedon, the special needs homeschooling representative on HEAC, will address later in her testimony. This section changes may to shall in regards to school boards adopting a policy regarding participation and equal access. I believe many of the problems we've seen this year aren't because they don't want to provide this access, but because they don't know how. So finding the 30 districts that don't have a policy and having them put one on the books would be very helpful so that people know the rules. Section 2 provides a more complete definition of how education is delivered at home. As many parents seek out specialists or workshop experiences to enhance educational opportunities, and it also removes some words that have created a lot of confusion. Section 3 addresses notification, and in particular, confusion about when a family that moves out of district needs to notify and whom. This essentially provides a framework that notifying through the district, well, it establishes the existing framework and puts it into the law, not the rules that people don't know to look for, especially as a new homeschooler. It makes it clear that notifying through the district or a non-public school is statewide, so if you move within the state, you're covered. But if you notify a local school district, if you move from that district, you tell them that you've moved, and then you notify the new district. It's current, and as I said, it's in the rules, but especially our new homeschool parents don't even know that there's homeschool rules. I do have some language that I can offer that does have some clarifications because admittedly some of that language is clunky, so I have some to offer, but I know it comes through the committee. I just wanted to try and fix my own mistakes instead of putting all that burden on you. Section 4 is the major equity issue here, and I want to be clear that we know exactly who we're discussing today. This is the only bill in front of the committee this year that deals with 193A homeschoolers. These are the classic homeschoolers, the ones we've always known before this new EFA program. Those ones are regulated separately under another section. These are the families that pay their property taxes to support their public school, but don't send their kids there. And they take the time, money, and effort to educate their kids themselves at home with whatever specialists they work with and do it at their own expense without taking a penny from the taxpayers. They want to do everything right. And these are the families that not only want to know what the laws are, but they want to make sure that they're clear so they aren't making a mistake. These parents take education and accuracy seriously, so fixing this language to make it easier to follow would be a huge benefit for them so that instead of trying to figure out the intricacies of our laws and rules, they can focus on educating their children. Now, some of these students learn and test well above grade level. You'll hear testimony from the National Home Education Research Institute about the tremendous performance of homeschoolers. If advanced students want to use national assessments that are 2 or 3 years ahead just to find the weak spots, do they have to take one at grade level to show that they can meet these standards? And then we have other students that don't test well, or maybe they're really far ahead in reading, but math is hard for them. And instead of trying to advance them, they're digging in and building those foundations, even if it's at a slower pace. If their math score is 20th percentile and their reading is 99th percentile, do we average it? The law is silent, and it leads to a lot of fear and confusion. Removing that 40th percentile would be consistent with most of the other states in this country. And even more importantly, it's consistent with every single funded student in this state. All of the taxpayer-funded students, not a single one of them has to hit a certain score. Yet we ask that of our entirely self-funded homeschoolers. So Section 5 addresses a longstanding issue, but with COVID, it's even more important. We had a lot of families that never wanted to leave their public school, but either because they didn't like the masks or they thought the risk even with masks was too high. They chose to step out of the public school until they were comfortable returning. Some of these families have been asked for a portfolio to go back into 3rd grade. The language was clunky. I have a better section to offer to suggest it in, but I know I'm not introducing the amendments, so that we can leave to later. And also just discussing the rules, doing rules changes. Everything that's in the rules for homeschooling is already in the law. It's redundant, it has some clarification that people look to, but all of the important points are already in the law. So to summarize, today we're talking about the unfunded 193A homeschoolers who subsidize the education of their neighbors while not taking a penny of taxpayer money to educate their children. These families invest time, effort, and their own money into providing the best individualized education for their kids. These families look closely to the law because they are conscientious and want the best for their kids. And these students, these unfunded 193A homeschoolers, currently have to fight for equal access in public schools, stress about whether tapping subject matter experts in group workshops for more than 50% of their educational time is okay, and how to handle notifications if they move, whether they need to worry about how they're demonstrating reasonable academic proficiency standards that are more strict than any other student, and about whether their students will be placed with their age peers if they do go back to the public classroom that they had left due to COVID. I urge you to address these current concerns. Thank you, and I'll take questions.
Thank you very much, Representative. Are there questions from the committee? Representative Cordelli.
Thank you, Mr. Chairman. Thank you, Representative, for bringing this forward. Just so that we're clear, we're talking in your legislation about homeschoolers, not parents who are homeschooling with an EFA account. They are a separate attendance category, as I understand it. Is that correct?
That is correct. These are the people who are 193A homeschoolers. There was already a method. Last year with the EFA accounts, there was a new section of law created for EFA students, regardless of whether they're educated in a private school, at home, or any of these other combinations. They have an entirely different section of law, and unless they gave up the EFA, they would not touch the law we're looking at today. These are the people who do not want the state money and are very happy to do it on their own and are very happy to have a separate section of law.
Thank you. Further questions? Not seeing any. Thank you very much.
Thank you.
I'd like to invite Robert Clegg, Honorable Senator Clegg. It's been a few years since you've been in the Senate here. You can hit the button there. Great, thanks.
You can't train a senator, I'm sorry.
But I agree.
Thank you, Mr. Chairman, members of the committee. I know for the last few days you've been dealing a lot with the Education Freedom Account, and I just want to help point out that this bill is not about the EFA program. It instead is specific to homeschool students, and it's governed by 193A. And as the previous speaker said, these are the people that don't want the state money. What I'm going to do is I was asked by Dr. Brian Ray to read his statement for the benefit of all the people who watch you on camera. I usually watch you on camera myself. It's very brief, and I'll go fast. Honorable legislators, thank you for allowing my testimony on HB 1663. My name is Brian Ray. I have a PhD in science education, MS in zoology, BS in biology, and I'm a former certified teacher in public and private schools. I've also been a professor at the graduate and undergraduate university levels in the fields of education, science, and research. I have done research on the homeschool movement for about 37 years, and I'm president of the National Home Education Research Institute in Salem, Oregon. 40 years of research studies by various scholars show that homeschool students typically outperform public school students by 15 to 30 percentile points on standardized academic achievement tests. The majority of research also shows that the home educated are developing socially and emotionally better than the public schooled, and the homeschooled do as well or better than the conventionally schooled in adulthood in various spheres of living. Nevertheless, just as some public schools and private school students score below average on achievement tests, whether that means 10th, 20th, or 39th percentile, so do some homeschool students. Current law states that a homeschool student must score at or above 40th percentile. It's crucial to note that at about 39% of all public school students score below the 40th percentile on nationally normed achievement tests. Yes, 39% of public school students, by definition, score below the 40 percentile. Permit me to explain a few main reasons why the mention in law of any cutoff test score with regard to homeschooling is wrong. First, it is discriminatory practice toward homeschooling as a legal private educational opinion. To be equitable, if there is to be a cutoff score for being free to continue in homeschooling, then there should also be the same cutoff score for being allowed to continue in public school and private schools, regardless of whether they are religious or secular independent. But there is no cutoff score for a student to continue in the public school or in private institutional school. Neither state law nor public school teachers nor teachers' unions are arguing that there should be a cutoff score of the 40th percentile for public school students, and that 39% of public school students should be mandated to attend private schools or homeschooling. Second, there is no sound pedagogical reason to have different, that is, lower standards for public schooling and private schooling as compared to private homeschooling. This is especially true in light of the fact that such a large portion of public school students have been found to be below proficient on the national NAEP testing program, and when so many public school students have shown such little educational growth over the past 2 years. Third, such a cutoff score for homeschooling, or any kind of schooling, ignores the reality that there will always be a given percent of students, whether public schooled, private schooled, or homeschooled, below any given percentile cutoff point. The important thing in education is not whether a student is below point X or Y on a standardized test, but whether the student is making appropriate educational progress. A homeschool student or a public school or private school student moving from the 20th percentile 1 year to the 27th percentile might indicate tremendous growth in learning. All educators should know this. Fourth and finally, research shows that the degree of state control and regulation of homeschooling is not related to an academic achievement. Achievement test scores of homeschool students in state with higher regulations are the same as states with lesser regulations. Thank you for allowing me to speak. Brian Ray. And Mr. Chairman, there is a set of references, and I will pass out enough, I believe, for the whole committee. And I take questions, but I'm not sure I'm smart enough to answer any.
I won't comment on that. Thank you. Are there any questions from the committee? You're off the hook.
Thank you very much.
Yep. I'd like to invite Michelle Lavelle.
Good morning. My name is Michelle Lavelle, and it's a pleasure to be back in the House Education Committee. It's been a while, so nice to see you again. In the interest of time, I'm going to abbreviate my comments. I have copies that I'll distribute to the committee afterwards. I'll even email them to you so you can see the hyperlinks and check out the research for yourself. My name is Michelle Lavelle, and I am the director and a co-founder of Granite State Home Educators. GSHE is an all-volunteer 501c4 nonprofit. We have approximately 6,000 members around the state and 9 social media accounts with over 14,000 participants. GSHE supports 1663 because it addresses important aspects of home education statute. It resolves some housekeeping inconsistencies and gives parity to homeschoolers relative to students in other educational programs. And I can't emphasize enough, this bill impacts unfunded homeschoolers, students that follow 193A, not those participating in education freedom accounts that are governed by 194F. We need to make that distinction clear because I've heard in other testimonies and discussions a real confusion on that point. So these are the unfunded traditional homeschoolers here. In the interest of time, I'm going to skip significant sections and go right to part 4 that removes the unequitable academic achievement thresholds and provides protections for home-educated students with special education differences. Currently, unfunded homeschooler students are the only educational pathway that has individual student academic achievement requirements written into state law. The current home education statute says that a child must show, quote, progress commensurate with age and ability. It further states that if a family uses a standardized test for the annual assessment, that the child must achieve a composite score at or above the 40th percentile to demonstrate academic proficiency. Achievement at or above the 40th percentile means that 39% of students fail automatically. This standard is unique to unfunded home-educated children. By comparison, Prentice students who are enrolled in the Recovering Bright Future program and are funded by a $6 million federal grant may opt out of the statewide assessments like their public school peers and have no academic achievement standard. Funded Education Freedom Account students have no performance requirement, yet have an average of $4,500 of state adequacy money follow the child. Students participating in town tuitioning programs also have no academic achievement requirement in statute and have local tax money follow them to an out-of-district or private school. Students in public schools cost an average of $18,000, yet do not have individual academic achievement requirements in statute. Just like other states, New Hampshire's public schools struggled with learning loss in 2020 due to the pandemic. However, the statewide achievement scores indicate generally low proficiency across all 3 subject areas well before COVID was a factor. According to state statute RSA 193-H:2, public school districts were required to have, quote, all pupils at the proficient level or above on the statewide assessment by the 2018-19 school year. That benchmark was not achieved. In my written remarks, you will see what the scores have been over the last 6 years. In addition, public school students may opt out of the statewide assessment per RSA 193-C:6. Home-educated students are required to do some kind of annual assessment and do not have an opt-out choice. The academic achievement on a standardized test of the 40th percentile or above is clearly an unequitable requirement, particularly given that home-educated students do not receive federal, state, or local dollars. 1663 also seeks to protect homeschooled students who have special education challenges. They are a fast-growing segment of the homeschool community, and they need clear protection stated in the law. The current statute says progress commensurate with age and ability. HB 1663 provides language that acknowledges and protects those students who have disabilities by explicitly taking their differences into consideration for their annual assessment. Note that the proposed changes to RSA 193A:6 do not remove the annual assessment requirement. Home-educated students are still required to administer some type of assessment, and the options remain the same: a standardized test, an evaluation by an education professional who either has certification or is currently teaching in one of New Hampshire's private schools, or another agreed-upon method. These are not altered in HB 1663. In closing, please support thousands of unfunded home-educated students and pass 1663. Homeschoolers are not asking for funding, services, or special favors. We simply want some important details cleaned up in the statute: privacy, explicit protection for our special ed children, and a level playing field. Please give 1663 an ought to pass vote. And with that, I'll take any questions.
Thank you very much, Michelle. Are there questions from the committee? Not seen. Thank you very much. The next person is Abigail Bellamore. Can you put if there's a, when it comes on red, you're live. There you go.
Abigail Belmore from Chester, New Hampshire. I am in support of the bill. I will be sending an email to all the committee members. I'm going to be short and sweet. I am in support of the bill. I am in support of this bill by changing the wordage in several phrases throughout the homeschool law to clarify and make it easier for homeschool families to read the letter of the law and also give us a documentation to present to our school districts when we want to have a public access to classes that would enrich our students. Stating that homeschoolers are being held at a higher standard than regular public schools needs to go, and learning disabilities need to be held at a level at which the children learn with that disability. Returning students to the public school needs to be that are being discriminated because they are homeschooled either by short or long term need to be allowed to enter at their grade and level of age, not on factors that the school feels that they need to be in. Notifications need to be clear where we're sending them and how we are sending them, whether we are beginning or ending our homeschool education, whether we're sending it to a public or to the state. A lot of confusion happens. Like I said, short and sweet.
Thank
Any
you very
questions?
much. Thank you. Are there questions for the presenter? Thank you very much. Next person is Sarah Scott. Welcome again, Sarah.
All right. Thank you, Mr. Chairman and members of the committee for the opportunity to provide testimony today. My name is Sarah Scott, and I'm the Director of Grassroots Operations for Americans for Prosperity here in New Hampshire. And on behalf of Americans for Prosperity New Hampshire and our activists all across the state, I urge you to support House Bill 1663, a bill which clarifies the requirements for home-educated students. And this legislation really does make several very important clarifications. So first, it ensures that each of the districts shall have a policy in place for home-educated students who participate in classes and extracurriculars. State law already requires that these districts allow these students to participate, but there is some confusion among some districts as to what that policy looks like. So this bill would just clarify that and make sure that school educators and staff there would have a clear understanding of how that policy works. And I think that this bill would really guarantee that students are not left waiting if they're wishing to participate in classes or extracurriculars. There was at least one instance over the past year where a district was unclear on how these students were to be integrated, and there was time that the student is sitting there waiting to participate. I just wanted to kind of clarify that I know firsthand the importance of giving these home-educated students access to the classes and the extracurriculars. Between my two sisters and I, we were homeschooled, public school, private school. We did all the different options at one point or another. And throughout the time that we were home educated, I participated in classes at the local public school. I did foreign languages, gym, art class, while my sisters participated in various sports. And without the opportunity to take these classes, I think our education would have been a lot different. And so I really think it's important that we make sure that we have a policy amongst each district for how these students can participate. So next, this bill clarifies that home education must be provided, coordinated, or directed by a parent. Over the last 5 to 10 years, education has really become more unbundled than ever before. We're seeing parents take advantage of opportunities that we haven't seen before. And so this legislation makes it clear that parents don't need to be the only educator in their child's education. And then just lastly, this bill makes certain that home-educated students with disabilities are evaluated with the same standards as children with similar disabilities that are in a traditional school setting. This is a straightforward and reasonable expectation that I think we can all agree makes sense. These students should absolutely not be held to a higher level of assessment than a student in a more traditional setting. So it's for these reasons that we ask you to support the passage of this legislation.
Thank you very much. Are there questions from the committee? Yes, Representative Waltz.
So again, I'm not quite as familiar with this as some people, and I've been sitting here reading it, and what I see is that there's a choice among parents. We are not mandating that they take a standardized test and score 40%. There's a choice. So if a parent is concerned about the 40%, would they have a choice of using an alternative method to determine competency?
Thank you for the question. Yes, there is a choice. A lot of parents do like to use the standardized assessments because it's easier for them to track their students' progress over the course of the year, but they do have different options.
Any further questions? Thank you. We have a card from J.R. Hole, previously Representative Hole. Welcome, J.R. At one time sat on the Education Committee.
Is it good? Yep. Okay. For the record, Representative Hull, State Rep from 2010 to 2018, sat on this committee my first term. I am here in support of this bill with the idea that some changes need to be made. For the record, my wife and I have homeschooled our children from kindergarten through grade 12 for the oldest two, grade 10 for my daughter, and grade 7 for my youngest son. I'm going to, as a brief amount of testimony, my oldest two, one has a 392 at UNH, is paying his own way through school without help from parents, without school debt. My second child is a sophomore, has a 4.0. He's paying his own way through school while he's working a job at Manchester Community. And clearly, homeschool parents can do a good job. Section 1 and 2 are great of this bill. I love that. I echo the concerns about the 40th percentile, right? Because the 40th percentile, as someone else pointed out, means 39% of the students in this average distribution would be below that level. Statistically speaking, that's not a good percentage, and not everybody is going to be capable at that level just because of their natural abilities. So I understand there may be an amendment coming forward at some point. It's the Representative Leon amendment. I just briefly read through it just now. I saw no issues with that amendment. I am in support of those changes. I am concerned about the fact that as parents move from district to district, the notification issues get pretty ugly and squirrely. If you've notified your prior one, now you got to notify your new one. At one point, we were looking at whether you even need some level of notification. Because if you notify the town and then you move to another town, right, it just gets ugly. At some point, I'm not sure that notification is necessary, but that's not this bill, and that's for another day. Okay, I would ask that you would support it with the changes that were proposed by Representative Leon, and that ends my testimony. I'll take any questions if there are any.
Thank you very much. Are there any questions? Yes, Representative Waltz.
Would you believe that the committee does not have an amendment from Representative Leon, so we have no idea what you're referencing?
No amendment has been presented.
Okay.
We don't accept it
Okay.
until it comes from a member on the committee.
Okay. Have you guys been provided a copy of that amendment? No. No, at all? Okay.
No.
I will make sure that I email the secretary at least that, and hopefully one of you guys will introduce it at the executive session. Thank you.
Thank you. Further questions? Not seeing it. Thank you very much. We have Amanda Whedon.
Hello.
No,
Right before. Press the button again. I have a red
There you
light.
go.
My name is Amanda Whedon, and I'm a home educator here in New Hampshire. I think that this is the most important descriptor in the list of roles I'm about to share because this bill directly affects me and my family. I am a leader, co-founder, and board member of Granite State Home Educators, the most active and supportive homeschool community in New Hampshire. A handful of us spend an inordinate amount of time in our network of Facebook groups supporting, educating, and advocating for homeschoolers in New Hampshire. We maintain the premier website for resources in our great state, host countless info sessions, events, meetups. We mentor, encourage, and assist home educators of all kinds, online and in person. I'm also a leader in Christian Home Educators of New Hampshire and Southern Maine. Formerly Seacoast Christian Home Educators, we made the move during the pandemic to a statewide, non-denominational Christian support group. And at just shy of 1,000 members, we're extremely active politically and in our local communities across New Hampshire. I'm the Special Needs Homeschooling Representative on HEAC, the Home Education Advisory Council, appointed by the Commissioner. It is my job to remain keenly aware of legislation, guidelines, issues, and concerns that involve special needs homeschoolers, and to represent the best interests of special needs homeschoolers to the public, the Commissioner, the Department of Education, and the legislature. I'm a special needs homeschooling advocate. I spend my free time counseling, supporting, and encouraging special needs homeschooling families. I create content for workshops, my YouTube channel, and Granite State Home Educators website, blog, and newsletter. I hoard curriculum. I compile lists and share everything I know with anyone who needs help, free of charge. I do info sessions on the homeschool law in New Hampshire. I make phone calls to public school superintendents and principals. I go to school board meetings. I email legislators. I created the only special needs inclusive co-op for homeschoolers in New Hampshire last September. I use my sphere of influence to help build a homeschool community that is strong, that is fierce, that is here, and that is mobilized. I'm a veteran homeschool mom. I homeschool 4 children ages 15 to 6, and I'm a special needs homeschool mom, and I'm here testifying because all of this makes me an expert on home education in New Hampshire. Now, I fully realize that there are people who probably signed in on this bill who might be here today to testify as well, who not only are not homeschoolers, but probably don't know the first thing about homeschooling or the homeschool law in New Hampshire. There are organizations that saw Home Education Committee and Home Education and signed in for opposition, probably without even reading the bill. I'm not a public school parent. I'm not part of a teachers union. I'm not an educational lobbyist. I am an expert in home education in New Hampshire, and I've spent years earning the privilege to speak here today on behalf of the homeschool community. A brief explanation of this bill should clear up any misgivings one might have as to whether or not HB 1663 is needed, necessary, or even relevant. We have 5 objectives in this bill. This bill requires school boards to adopt an equal access policy. It's a simple change of the word may to shall. I want to make sure that you understand what equal access means and what it means to this bill. The current law states that home educated students have the right to curricular and co-curricular activities at their local SAU. Public schools may not treat homeschoolers any differently than enrolled students when signing up for classes, programs, prom, math club. This is current law. Homeschool families pay taxes just like public school families, and this is a legal right. In New Hampshire, there are dozens, at least, of public school districts that either, 1, have no written guidelines whatsoever, or 2, have extremely outdated and often, therefore, illegal guidelines. Did you hear about that homeschool advocate who challenged the Rochester School District, ultimately resulting in the DOE taking legal action against the district for discriminating against homeschoolers? That was me. Ask me to tell you the whole story another time. It's exactly why this one-word change is needed. Since I sacrifice my time to educate and correct public school districts regarding their non-existent or outdated policies, I think I know what I'm talking about when I say Rochester's was from 1996, their policy. The law needs to be updated by changing the word may to shall. Number 2, removes language that could imply home education needs approval by a participating agency. Parents direct their child's home education, period. By adding the language coordinated or directed by for his or her own child, the law would make it explicitly clear that it's parent directed and inclusive of both genders. It only says him. The second part, unless the provider is as otherwise agreed upon by the appropriate parties named in paragraph 2, what? No. That part needs to go. There's no other appropriate parties to agree on anything. The participating agency does not have this power legally, and the law should reflect that. Number 3, eliminates inconsistencies regarding who to notify and when. This is a long overdue addition. I'm asked regularly across all media groups, in person, on the street, in line for coffee, exactly the questions that this edition answers. Notifying agencies, okay, we have options: participating agency, a private school acting in that capacity, the Department of Education, or your local SAU. Notifying agencies need to know if a homeschool child moves out of state, if they move to a different district. This is a simple and clear change to the language, making it consistent. Number 4, removes academic performance thresholds and provides protections for home-educated students with special ed differences. This part is my jam. This part is why I really, I'm here, brought my kids, didn't bring them in person, you're welcome. Homeschoolers are the only educational pathway that have an individual academic achievement requirement in statute, even though they're not supported by tax dollars. This is mind-blowing, okay? Allow me to give you a quick example how to illustrate this. So, number 1, it's unfair. Number 2, it's unjust, this portion of the law. So we're going to talk about donuts. Let's say 3 kids get hired to make donuts. The boss tells all 3 kids they must each make at least 40 donuts per shift. The first kid makes 63, but the boss doesn't care. He didn't even ask how many they made. The second kid makes 27, and the boss didn't ask that kid either. The third kid makes 13. The boss asked this kid, how many did you make? And then fires that kid for not making at least 40 donuts. Is this fair? Is this just? Of course, this is a silly example about donuts. And it's easy to see why treating 3 kids differently is unfair. It's easy to see that it's unjust to fire the one kid if the boss didn't even care about what the other kids made. Now imagine this, the third kid has severe dyslexia and couldn't read the recipe. In New Hampshire, homeschooled students have the requirement of year-end assessments. None of the tweaks in this bill changes that. Parents typically choose one of 2 options, standardized testing or portfolio review. Parents choose which standardized test to administer, who to hire as a certified teacher to review the child's portfolio. If a parent chooses a standardized test, the student must achieve at least 40th percentile. This is written in the homeschool law. It's not written in the law for public school students, not for private school students, not for funded EFA homeschool students, not for Prendapods. In fact, homeschoolers are the only educational pathway that has this academic achievement requirement, but we're not funded by tax dollars. And it's a mystery. Why would unfunded traditional RSA 193A homeschoolers be held to a higher standard than any other educational option? But this portion of statute, it needs to go. It's unfair and it is unjust. And just like my donut example, it is unfair and unjust to treat my kids different than the public school children. It's discrimination. Children like mine with special needs, learning disabilities, and those who need accommodations or modifications are not able to be in compliance with this portion of the law if I choose a standardized test for my child's year-end assessment. I could speak on this point for hours since time is short, and as an expert in special needs homeschooling, I will say this. Special ed homeschoolers should have their disability expressly considered in their annual assessment. This bill accomplishes that. My last point is that currently public schools use arbitrary and subjective means to determine the placement for homeschoolers wishing to enroll, re-enroll after coming from a home education pathway. We've stuck it out with hundreds of families who, for whatever reason, decided to temporarily homeschool their children. So as some of these families did decide to re-enroll in public school, some of them were met with resistance. Some of them were met with, quite frankly, opposition and treated differently than kids who were re-enrolling who were not coming from a homeschooling traditional RSA 193A pathway. So instead of placement in elementary and middle school by age and address, which is typical, they were asked to provide portfolios, which we must keep as part of our home education program, and year-end assessments. So these children were asked for proof of their education. No other students are asked for that in elementary and middle school. They're assigned their classroom by age and address. So this bill clearly states a non-discrimination policy if homeschool students re-enroll in public school. So these 5 main points of the bill are important. They're long past due, and there's nothing of concern for taxpayers. Let me say that again. Nothing of concern for taxpayers. There's nothing to object to. The fact that Representative Land had taken the time to craft this legislation points to the need for your ought to pass a vote. She's also a homeschool mom and understands the importance of clearly updating this statute to reflect consistent, equitable treatment under the law. In closing, I'd like to thank you, members of the House Education Committee, for your service and your dedication to equitable, fair, just education for all New Hampshire children.
Thank you very much, Amanda. Are there questions? Representative Cordelli?
Thank you, Mr. Chairman, and thank you for being here today. Thank everybody for being here today. We've had a lot of discussion recently, especially about federal IDEA law and the fact that whether someone leaving a public school might lose the ability for services provided and mandated under IDEA law. As a homeschool mom, you are not covered by IDEA. I take it is possible for a mother of a child with needs to get the services that you feel are necessary for your child without the benefit of federal IDEA law. Is that correct? And are there many parents of special needs children who are homeschooling?
Yes, absolutely. And we are one of the, this population has been growing, especially during the pandemic. Kids who are in a public school setting, their needs were not being met due to the nature of the mess that it was. So these kids were not being supported, their IEPs, their 504 plans were not being followed, either lack of staff, I mean, we know. So we had a surge of homeschoolers, period, but that specific population is growing. And that's not just a New Hampshire thing, that's across the country. So my son, he's now 11, and he has a list of diagnoses, and he has never been outside of my care. So he's never been educated outside of my home or underneath my direction. And my son is thriving. He is safe spiritually, he is safe academically, he's safe emotionally in my care. So there are many, many resources available to all homeschool families, but those that are particular to special needs homeschoolers, and this is again part of what I do, is provide this list to people. At-home therapies, most of us turn to private therapies through private insurance, which tend to be a better fit for our children because a home-educated child is not in a public school setting. We don't need them to perform and to stay within the box, so to speak, of a public school setting. So private therapies are a better fit usually for our family. So there are scholarships, there are grants, there's a whole big world out there of curriculum, of at-home options for all different types of therapies. And again, so part of what I do is provide those resources to these families. And if my kid, I wish I could have brought him today because he is a treasure, he's a joy, and he deserves equal protection under the law.
Thank you very much. Are there further questions? Representative Woodcock.
Thank you, Chairman Ladd, and almost good afternoon. Just a quick question. I've listened to 2 or 3 speakers already, and they're talking about the numbers of youngsters participating in the 193 phase of the education options in New Hampshire. Do you have not the number of social contacts or media outlets, can you tell me how many I was thinking about the district transfer and all this thing. Is there a repository of a number, or can you tell me the number, or does DOE have the number of students participating in the program?
That are traditional notifying RSA 193A homeschoolers? I just want to make sure I understand the question.
Yes.
So they do have a number, but to explain a little bit, we went from notifying every year in years past, right? The law changed so that now we notify only one time. And this is, again, why this legislation, this tweak here is needed, because how are we keeping track? If someone moves from a district to another district, well, they notified with that district, and now do they notify again? Who do they tell that they moved? This needs to be addressed in the law. So there is a notification. We do need to look at that piece, aside from this tweak, which will help. But the Department of Education, really, they get a number from the participating agencies. So the private schools that act as PAs, they just get a number. This is how many notified, right? So the public school enters it into their database. They also provide a number, right? So I assume the DOE totals that all together. But because on the back end of this, we don't have a good system. So when a student leaves, goes to another educational option, it's muddy. Yeah.
So,
go ahead.
Just so, with all the mud, can we cipher out or call out a number? Do you have a relatively accurate, as a self-professed expert here, of what the number is?
So I would say there is not an accurate number. So the Department of Education, and I'm sure Michelle or Erica can provide that information directly from the Commissioner of the Department of Education, but because of all these things that I'm saying, it's not an accurate number.
Okay, thank you. Thank you, Chairman Ladd.
Further questions? Yes, Representative Mullen.
Thank you, Mr. Chairman, and thank you for taking my question. Are there school districts that are already integrating homeschooled kids into curricular and co-curricular experiences? And if so, are there model policies that you have access to?
Yes, so it is actually fairly common for students to take classes. It's curricular and co-curricular, so basically this is anything. So if they want to join an after-school club, if they want to go for chemistry lab, any of these things are legally a right for tax-paying home-educated families. So yes, there is a tremendous amount of homeschoolers that utilize this kind of a la carte to create their homeschool program. And so the experience that I have had in dealing directly with districts is they don't know what they don't know. Okay, so the Rochester district, for example, had to be taken to the extreme level of legal intervention. Typically, when I call, or Michelle, or so one of us calls a school district, we speak to them and let them know, this law is here. Let me email you this law and give me a call and we can go over it. They honestly either don't know, they really just don't know, or it's so outdated and they don't know how to update it. So this part of this updating of the law, that's why this is so important. We want the public schools to have an easier time. They don't want me calling them saying, you guys, this is from 20 years ago. Nobody wants that. We want everybody to be on the same page, right? So that they know this is the law, this is how we accomplish the law. There isn't a standard set of guidelines. That is something that I think would be amazing because, again, the wording, they just don't know what they don't know. I do know for a fact that the Rochester School District did legally have to update their policy, so they have one, and it's a great place to start. Yeah.
Thank you very much. Further questions from the committee? Representative Luno?
Thank you very much, Mr. Chair, and thank you very much for joining us this morning, and it's great to have an expert to provide the committee with information. Sort of getting to what's in homeschool and what's in public schools in particular. That was one of the things that you sort of addressed that this bill would help facilitate. But I was wondering if you could comment on whether or not the homeschool statute 193A:4 refers to the same minimum academic standards that exist for public schools in 193E:3. So I can ask the question a different way. Are homeschool standards the same, held to the same minimum academic standards for public schools?
So we have a separate set of requirements that in many ways mirror a public school, but our subject requirement is listed in very plain language in the law. So our academic requirements, everything falls upon the parent. Accountability falls upon the parent, and that is the way the law is written for homeschoolers, and that is the way that it should be. When you were 5, you were held accountable to your mom, your dad, and the same goes for education. And homeschoolers believe very strongly that the educational requirements need to be followed, but also that we have the freedom to craft our own child's education.
But a follow-up, Mr. Chair, that's fine. I'm not arguing with that. But are the standards the same for homeschoolers as they are for public schools, or is it different?
So we are required by law to choose a year-end assessment. And so we have options in that. There are 3 currently in the law. 2 of them are what most people choose.
Just to clarify, I'm talking about the minimum academic standards. Are
So
they the same or different?
we are a different educational pathway than public school students. And much like private school students, Prenda pods, or any other educational pathway, including the EFA funding, we have our own set of academic requirements.
Thank you very much. Are there further questions from the committee? Not seeing any. Thank you very much.
Thank you.
I'd also like to take the opportunity here to thank all our homeschoolers that came today. I'm looking around at the crowd in front of me, and it looks like I'm seeing somebody between the ages of 2 and possibly 3 out there. And I've seen a toddler go out that's probably not even to 1 yet, or about 1.3 or something like that. And really appreciate the way homeschoolers are always behaving and on task and listening. We do have one more here. I didn't have that one presented to me. However, I just want to compliment you on what you're doing here. And this is a unique program as it is in our state. And it's been very successful as well. So with that, I'd like to have the last person to testify. Evidently, we just received this card from Roseanne Chester. She left. Ah. Jeez. Yeah, we need to have these up here because now we're going to be stringing this thing out. I am going to put a time limit on the remaining cards.
Absolutely. I apologize. Thank you, committee chair. Thank you, committee member. I'm sorry, I didn't know that my pink card had gotten up there, which is why I'd left the building or left the
Can
room.
you hold on one second?
Yes.
I want to see how many we got coming here. We are going to have to put a time constraint on all this.
I will be less than a minute.
Okay, go for it.
Okay. My name's Rationale Chester. I currently live in Bedford, New Hampshire. My history is older than that, so it's not from the town that I currently live in. However, I had two special needs children. One was coded severely emotionally disturbed because that's the only way that I could get her the services that she needed because in the public school system because of her IQ status, and she refused to be homeschooled. The other one had significant emotional disabilities, and I can tell you right now that that school system wanted my so they were both labeled severely emotionally disturbed, but my my younger child had other learning disabilities as a result of that as well. When it came time for the standardized testing, they wanted my child that had learning disabilities to stay home so that they would keep their standards up. They wanted my child that was exceptional to attend so they could keep their standards up. So the bottom line is that forcing homeschoolers to represent that, to do that, the school systems are already manipulating the facts. It's time to stop. And holding homeschoolers to a standard that we're not holding our public schools to that same standard. They found a way around it. And that's all I have
Thank
to
you
say.
very much. Other questions? Thank you very much.
Thank you.
I'd like to call Isaac Shea.
Thank you guys for letting me come up here. My name is Isaac Shea, and I support the HB 1663 bill because my parents, along with other homeschool parents paying taxes, shall have the same rights for their students as public school students to participate in the same activities as other students. Our parents are paying taxes just like everyone else. Please pass the HB 1663 bill and protect our students' rights. I'm here today to represent what John Holt said, quote, "It is the duty of citizens in a free country not to fit into society, but to make society." Thank you all.
Thank you very much. No clapping, not allowed. We'll close it right down. Okay, Adriana Folo, F-O-L-O? I'm trying to read it correctly for you.
Adriana Batafico.
Okay, thank you, Adriana.
Hello, my name is Adriana Batafico, and I am testifying in support of House Bill 1663. I have lived in the great state of New Hampshire for over 20 years, and during that time, I have paid property taxes, a large portion going towards the local schools. I home educate 2 children. However, over the years, I have not been able to access any materials from my local public school. As an example, 2 years ago, my child's laptop broke, and I approached the school requesting to borrow one for just a short period of time. They had been advertising that they had gotten a grant because of the pandemic, and they had extras. However, as a home educator, I was denied this request. I believe that all home educated children should have equal access to their public schools material within reason, and equal access to the school's classes, sports, and clubs. Education is not a one-size-fits-all. It is important for children to have options to best meet their needs. This simple change of the current wording of the law from may to shall will ensure equal access for all children in New Hampshire. This bill also provides much-needed protection for children with special education challenges, by allowing the consideration in their annual assessment. Please support House Bill 1663, and thank you for the gift of your time and consideration of this bill.
Thank you very much. I'd like to call Angel, is it Brisson?
Brisson.
Yep, thank you.
You're welcome. Say hello and thank you for your time today. I'm entering this testimony for support of HB 1663 into the record.
Would you please not read your testimony, try to condense it or summarize it?
Yep.
Thank you.
Because I'm going to keep it short and sweet because many of the salient points were already hit upon previously. Again, my name is Angel Brisson. I live in Manchester, New Hampshire, and my husband and I home educate our daughter. Because of that, we support this bill. I'm going to touch upon the salient points for our family. Firstly, regarding Part 2, the home education was designed to be directed by the parents. It's solely our right responsibility to educate our children, and so our family does not need to solicit input from the participating agency. So we need that clarification in that portion that says it must be agreed upon with the participating agency, because it was never intended that a home education program must be intended to be agreed upon by both parents. The participating agency serves only to acknowledge a letter of intent and to retain the letter and, of course, notify the Department of Education. Next, regarding Part 3, if our family ever moves to another school district, we just want it clear that we're only required to notify one participating agency, that we'd be terminating our home education program in that district and then starting in a new district. We don't want to be in violation or have someone say that we're in violation because of the incorrect inference that we'd be required to notify more than one participating agency. And even though it's been talked about quite a bit, I still feel like it's really important to reiterate the portion about the academic achievement requirements. We're taxpayers. We have a couple of properties here in the city, and we're paying our fair share of taxes, and yet our children are being held to, our child, being held to a different standard. It makes no sense that the 40th percentile is there for homeschooled students when there's no other child in any of the other educational tracks, all of which receive public funding, taxpayer funding. Again, the EFAs, the Prendapods, the public schools, Prendapods, public schools, and the EFA participants have nothing written in
2
statute.
minutes.
Have nothing written in statute, so it's just inequitable.
Yep.
And we don't want that for our family.
So your time limit is up. We've gone well over 2 minutes now.
Okay.
I'm
So,
giving everybody 2 minutes now.
Because it seeks to correct these fallacies, we're in support of the bill, and we request that you please pass it. Thank you very much.
Thank you very much. Carrie Lesage?
Hi, my name
Hi.
is Carrie Lesage. I'm a New Hampshire resident living in Candia, and I appreciate you listening to my testimony today. And I'll just briefly summarize. I'm coming strongly in support of HB 1663 because I think it would bring some really much-needed clarity to the rules for unfunded homeschoolers. And I wanted to just quickly tell you 3 important things about our family. As homeschoolers under 193A, we're completely unfunded by anybody besides ourselves, completely out of pocket for our educational program. We do pay our local taxes, support our local schools, very happy to do that. And lastly, we have nothing to do with the EFA program. Just to clarify, because I know it's been a point of confusion over the last weeks. So the reasons that I support this bill for our family is that it rectifies an inequitable requirement in our current law, which sets an achievement requirement for homeschooled students when the similar requirement is not in place for other educational pathways. And this is not in my written testimony, but just in response to a question that was asked earlier, for those of us who choose standardized testing at the end of each year, which our family does, I kind of prefer it for myself. I don't ever get concerned about it because my children happen to be people who test well and can meet those requirements with flying colors. But if we were in a situation where they couldn't, I could see it being a disincentive to take a standardized test instead and instead to choose something else. So just throwing it out there that I think, if the requirements could be made the same as for all the other educational pathways, it will help more homeschooling parents to feel comfortable as well using standardized tests if they choose to do that as their assessment at the end of the year. And then secondly, This bill just takes steps to clarify that it's the parents and not the school district administrators who are ultimately responsible for a child's education. We take our responsibility quite seriously, and we want to make sure that you know that we do. So, thank you, and I would ask you to support HB 1663.
Thank you very much. Okay, Jody Underwood. Jody, a long time since we've seen you here, SB 8, Croydon, et cetera, et cetera.
It's been a long time. I have my printed testimony if, thank you. Jody Underwood, I am chair of the Croydon School Board. I'm on the board of the School District Governance Association. I have a PhD in education, and I have been a school choice advocate in New Hampshire for many years, as is witnessed here. I am not going to read all of this. I'm going to try to summarize what my points are. I do support the proposed changes, but there are some ways in which this bill doesn't go far enough, in my opinion. So one is it's really easy for school boards to lose track of what they're supposed to be doing, about what, in particular, what they're supposed to provide to homeschool students. I've been on the board since 2010, and until I read this bill and looked at the RSAs behind it, I wasn't aware of everything we were supposed to do. I want that model policy, and I will help promulgate that around the state. So I'm going to go look at Rochester, so thank you, Amanda. That's point one, and I think it's a very serious point. This is how we learn what we're supposed to do, is what's on that must-do list of policies. So people have been talking about the inequities of the academic achievement, and it's not just that end-of-year test that gets affected, but it's also the co-curricular and curricular activities. Some kids aren't allowed to be involved in curricular activities because they're not meeting a certain standard, but if that's the case, then that should also be applied to the kids who go to public schools as well. That would make it equitable. So, I mean, for those two reasons, not to restate the other one, I think that language should just be removed so that it is equitable, because nobody's taking kids out of public schools for not meeting the 40th percentile, right? And so, sorry, it's hard to, to totally summarize, but I'm trying to be quick. Another reason to remove it is, I mean, the words, the phrasing, that it only implies that homeschool students have to perform at the 40th percentile. There's nothing in there that's explicit about it. So that's another reason to remove it. So it's really not a statute, and there's no consequences if they don't. There's nothing in there. It's really just a definition. So consider that when you think about whether to remove it or not. But I think, maybe to overstate it, arguing over how to change a rule that has no consequences and is not, in fact clear, is pointless and a waste of everybody's time, really. It should just be clarified. So that's it. So please vote OTP for HB 1663 and consider making the changes even broader. Thank you for your attention.
Thank you, Jody. Questions? Not seeing it. Thank you very much. Katie McLaughlin.
Hello, I'm
Hi.
Katie McLaughlin. I live in Hampton Falls. I've been homeschooling for about 12 years. My eldest is about to graduate and go to college. My youngest is 6. I'm a part of the Home Education Advisory Council, and I also am a part of a large network on the Seacoast with a lot of families. We do a lot of co-ops and a lot of mom schools. So it's been amazing over the last couple of years since the pandemic to see how many people have wanted to look at all their options for education. And so I've been part of a team of wonderful moms and dads who have tried to catch those people who are looking for the other options and just be able to gently counsel them and give them clear guidance on what those options are. So now that we have the EFA, that's one thing, and then the Prenda thing, we first want to just ask you to please remember that the 193 homeschoolers are unfunded, and we believe we have the right to our privacy and our liberties to direct, oversee, and provide the education for our children as we see fit. I do like the changing of the words by adding that parents can direct, not only provide it, but can direct it. Because what I see around the seacoast is people don't like to be isolated and on their own. They actually do like to work with other people. They like to be social. They like to look for help. And so people are doing that, and there's nothing wrong or illegal about asking a mom who's gifted in science to teach science and a parent who's gifted in another area to teach that, and they do that freely. And we should just make sure that that's allowed. So I like that change. And then the last thing I just wanted to bring up is this equal treatment. I have often heard of families, and it's usually at the high school level, going into a high school, often treated very well and allowed to go in and be part of sports or after school activities. My kids have done that, and it's not been a problem. But it's been quite shocking to hear schools seem to randomly decide that they are going to hold a family to a higher standard, such as, we will only accept your child's progress for work for 9th grade if it came from an accredited school. But in that same year, that school accepted kids into that same grade, 10th grade, from districts in other states or in our state that were not accredited. So that was an unfair standard. It was quite shocking for that family, and I think that to ask school boards to make a policy is not too much to ask. I think overall it's going to save school board time, it's going to save the administration time of the public schools, and it will save parents time, so they will know if they want to access the curricular or co-curricular activities, how they can go about doing that, and to know and have confidence that they will not be ignored and they will not be mistreated. That's all.
That's about your time.
Okay.
Thank you very much. Appreciate it. Deborah Mears?
My name is Deborah Mears. I administer Tri-City Christian Academy's participating agency program, so I have a different perspective. I also homeschool my son. Our school is located in Somersworth. I wanted to specifically address the requirements for termination. The language needs to be changed. When parents notify through our school, and they do from all over the state, their notification remains private. We're only required to send statistics to the state in the October report. It's inconsistent to require parents to send termination notification to the Commissioner of Education when that office holds no record of the family. It should go to the chosen participating agency only. One of the reasons that people choose our school is because we respect their privacy. Our letter of acknowledgement states that we do not give out any information without their consent. I would like to see that this bill could clear up that inconsistency, and hopefully an amendment has been or will be introduced to that end. Thank you.
Thank you very much, Deborah. Are there questions? Not seeing any. Thank you very much. Two remaining cards here. Mike Donnelly.
Well, thank you, Mr. Chairman. It's great to be back in New Hampshire in this committee room where I have been coming for 20 years as an advocate for homeschoolers, first as a member of the Christian Home Educators of New Hampshire, then as a Grafton boy, raised in Grafton, New Hampshire, graduated from Mascoma High School. It's pretty amazing. I pinch myself sometimes. I get to travel the world advocating for homeschooling freedom. Can you imagine a boy from Grafton doing something like that? Those of you who even know where Grafton is. My name is Mike Donnelly. I'm a senior counsel with HSLDA. Have a JD from Boston University, LLM from London School of Economics, admitted to the bars of New Hampshire, Massachusetts, West Virginia, DC. I'm even a professor of law. I teach constitutional law to Patrick Henry College students and international criminal law to Regent Law School students. My mom, hi Mom, she'd be proud. Maybe she's even watching in Grafton. She still lives there. We're an advocacy organization with over 107,000 member families. We represent their interests and other like-minded homeschoolers. And I just want to say this. I get to travel to a lot of capitals in my job. And I know that you are asked to do more than any other legislators in any other elected body in the world for, well, never has been so much asked for so many and given so little. I know how much you don't make. So I just want to commend you for your citizen service. You're true statesmen, and true citizen statesmen. So just real quick, hit on a couple things here. You've heard about how homeschooling has just exploded in terms of growth, and I think it's really great that you're looking at improving the homeschool law here. And I want to support the ideas contained in Representative Leon's proposed bill here, HB 1663. Some great ideas. There are a few additional ideas I think that could be added to it, and I believe she has prepared an amendment. And I want to tell you that with those changes made by that amendment, our organization would support HB 1663. And I know you don't have it, but I think you will soon. Hopefully one of you will introduce it, and we would support that. This bill would make it easier for current homeschoolers, new homeschoolers, public administration officials like the Department of Education getting less information, providing clarity to superintendents and others who deal with homeschoolers. So I think it would do that. When it comes to standardized tests, I just want to address a question that was asked earlier. When students take the national tests, they are sort of being assessed against New Hampshire standards in as much as New Hampshire has adopted state standards, because these nationally normed standardized tests do, test for those standards. So I think that was a good question. I support all the other testimony regarding getting rid of them, and I just, by way of comparison, give you a few other states that do require tests. By the way, most states do not require homeschoolers to do assessments or to submit assessments, okay? Made that change back in 2012. Representative Hull was actually the person who did that. Thank you, JR. But in Colorado, they set it at 13th percentile.
You have just about run out of time, so
And
wrap it up.
I'm wrapping up. Ohio's 25th percentile. West Virginia just made the change from 40th down to 23rd percentile. We've long supported the removal of rulemaking authority from the Commissioner of Education. You have a very good law. It's very clear. The Commissioner does not need to make rules, which is a tiresome, cumbersome process, so I would encourage you to take the opportunity to get rid of the rulemaking process, which I believe is included in the amendment that Representative Leon has produced. And I want to thank you for your kind attention.
Thank you very much.
Thank you.
And our last speaker today is Alyssa. Was that your mother that spoke earlier, or?
Yes, it is. I'll be quick and brief for the sake of time. Hello, my name is Alyssa, and I've been homeschooled all my life in New Hampshire. I don't believe that homeschoolers should be held to a higher standard than other students, and there should be special protections for those with educational differences. And also not with different diagnoses, but also, for instance, what if one student has English skills that surpass their age level, but that they struggle with mathematics? It would be extremely beneficial to that student to have advanced education in the English that they desire, in addition to getting the extra help they need in mathematics. This would allow them to grow to their full academic potential. It would also be extremely helpful to have equal access to the public schools, to be able to borrow instruments and other useful materials. This would highly enrich my education. For instance, I have wanted to borrow musical instruments before from my local public school, but have been denied. Homeschooling has been a great blessing for me to explore and expand on my various gifts and abilities, while also strengthening my academic difficulties. Please pass HB 1663 to continue to allow homeschoolers to have the best education tailored to their individual needs and interests and difficulties. Thank you for your time and consideration.
Well done, Alyssa, and thank you for coming today. Really appreciate it. Are there any questions for Alyssa? You're off the hook. Well, I thank everybody for coming today. We went through all the pink cards now, and I think your message has been communicated. So everybody have a wonderful afternoon. Yes, we're closing that hearing and we're breaking for lunch.
try this one.
Yeah, but I think we got something from Lindsay that said one.
We'd like to go ahead and start this afternoon's hearings. We have 3 of them scheduled. The first one on the docket is HB 1398. I want to apologize. We've had a schedule in the hallway, we've had a schedule in the calendar, and it's been off by 45 minutes or so, and it's a result of a whole lot of issues where things have been bumped around, and I do apologize. HB 1398 is an act establishing a committee to study the feasibility of centralized criminal history records checks in education. I'd like to welcome Carol McGuire, the prime sponsor of the bill.
Thank you, Mr. Chair. I'm Carol McGuire, representing Merrimack District 29, which is Allenstown, Epsom, and Pittsfield. This bill started as a constituent question. She runs a business supplying occupational therapists to the schools, mostly for special ed students. And they support a good number of schools because around here, there's plenty of them with an easy commuting distance. And she asked me why they had to get a separate criminal records check for every school. And I said, that seems bizarre. And I went and looked into it. It turned out it's a combination of different laws and rules that causes the trouble. The education statutes require everybody who works in the school to have a criminal records check. And it says that once such a check is delivered to the school, it is reviewed, the decision to hire or not is made, and then the records, the data is destroyed for privacy reasons. The Department of Safety, which conducts our criminal records checks, can only release them to government entities without specific authorization, or at least that's what I was told. And so it ends up that if you want to work in the morning at Deerfield Elementary School and in the afternoon in the Epsom School, which are like 5 or 10 miles apart, you need to have a separate criminal records check for each school. And if tomorrow you're going on to Pembroke, there's a third one. This struck me as extremely inefficient. And the more I looked into it, the more snarled it looked. And so I decided that this is one of the few cases where a committee is appropriate because the information and the context and the understanding of the issues is not in one committee. I mean, I've got a bill in my committee that might have been a study committee, but we're going to interrupt study it because we have all the skills and the context we need. This one needs somebody with an education background and somebody who knows something about licensing and something about criminal records checks. So those are the people that I asked to be on the committee. The first thing is that I don't know which other professions are working in the schools and likely to work in more than one school. I mean, your basic teacher doesn't. They work in one school. But the professionals who support special ed services may not be needed full-time in a small school. So they will work in more than one. And around here, that's easy enough because there's, plenty of schools to pick from. So we would want to find out who's affected, how often they move, how many schools they work on, and what else we could do other than a Department of Safety FBI records check. Because there are some professions, I believe, or at least I was told by the Department of Education, that the professional organization certifies these people are okay to work in schools. I'm not sure if that's true in New Hampshire or it's only in Massachusetts or wherever they were talking about, but it's an idea. If you could have the professional organization of speech-language pathologists, anybody who had the license was blessed and certified and has no criminal record and is safe to work in schools. It's an option. I don't know that for sure. I do know that the Department of Education set this up for school drivers and transport operators because they also work for more than one school, and it was a royal hassle for them. And so the Department of Education started collecting the background check data and saying, these bus drivers and transportation monitors are good to go to any school. And so that's what I would like to look into. What else? I'll answer whatever questions I can.
Thank you very much, Representative McGuire. Are there any questions from the committee? Representative Porter.
Thank you, Mr. Chair, and thank you, Representative McGuire. So this morning I introduced a bill that would require education service providers who are receiving EFA accounts and others that are receiving public money to have background checks. Would those people be able to utilize this, you think, if it went through?
That's why we have to study it, Representative Porter. I do know that the background check procedure is being used much more intensely these days than it used to be, and it is frequently a bottleneck for other professionals. And if somebody needs to get 5 background checks to go around to the local schools, that's 4 other people that couldn't get a clearance.
Further questions of Carol McGuire? Representative Litchfield?
Thank you. Would you believe we were just discussing this literally a few days ago at a school board meeting where we have an issue with subs? We could use a centralized location for substitutes because we have a shortage, and boy, this would really simplify things.
Yes, I'm sure. I'm not involved with schools very much, so I don't know which professions you would need or want to have a centralized database on, but I'm sure that it could be very useful.
Further questions? Representative Walsh? Yes. Representative Walsh?
Thank you. So I'm trying to remember, and we've heard a lot of bills, but my recollection is we've had testimony that the Department of Education is starting a centralized database for things like school bus drivers and some other support
Yes.
people. Is there any reason they can't do this for teachers and subs and
We have to authorize them to or tell them to.
so could we, instead of studying this, it appears that follow up?
That's fine.
Instead of studying this, wouldn't it make more sense just to amend this bill to tell them to do that and have a centralized base for everybody so that we can have all background checks and everybody has access to it?
If you know all the professions that need to be included in that instruction, I would certainly support it. But I don't know who's working in the schools other than my constituent, the physical therapist.
Further questions? We do have the department here, so we can get some technical advice there. We've been seeking it from our governor back there. Hands up in the air. Well, we'll elevate you then to full colonel. So at this point in time, if there's no more questions, we'll move on to the next person, which we have here, and we're going to get, let's get our New Hampshire State Police up here. Victor, is it Muzzey? Yes, sir. Muzzy, welcome.
Thank you, Chairman, and thank you, members of the committee. My name is Victor Muzzy. I am a lieutenant at the State Police in charge of Record Information Services, which includes the Criminal Records Unit. I'm here this afternoon to just offer a couple of points, I suppose. First of all, I think the Department of Safety would be in support of this bill to form a committee to study these items, which I think we would agree. Any way to alleviate backlog and make things more efficient, of course, we would be in support of that. Really, our only concern would be I suppose, making sure the committee is aware of a lot of the requirements that we would fall under for things like disseminating background checks and how those go to different places and is at the hands of the FBI and controlled by them. So as we saw with the bus drivers and bus monitors, we had a little issue there where we had to reach out for the FBI's say-so, even though a law was enacted by the state. Dissemination of that was really up to them because it contains CJIS information. So that's really, I think, our only concern is making sure that the study understands, or the committee understands in researching what need to be done to determine how we can disseminate these things. That a lot of this is at the say-so of the FBI. In furthermore, the other point that I will make here is line number 20 talks about the availability of other background clearance procedures. And I don't know exactly what the language in that may refer to, but if it's in reference to potentially doing third-party background checks or things like that, certainly that's not a decision for the Department of Safety to make, but just to make members of this committee or the committee formed as a result of the bill aware of what you would be getting in regards to that check versus what you wouldn't be getting, just as an educational piece. So I guess that's really what I can offer you in the way of testimony. We support the idea of it, and certainly the efficiency of I think, the intent of the bill. It's just a function of the logistics of carrying out whatever the committee determines, and that has making sure they have a full understanding of the confines of which we may have to operate under.
Okay.
Happy to take any and all questions.
Thank you very much, Lieutenant. Are there any questions here? Yes, Representative Woodcock.
Thank you, Chairman Ladd.
Yes, sir.
Sorry again. Thank you, Representative Ladd. Thank you, sir. I have two questions. The first one is there anything that in your mind that would, having dealt with all these certifications and checks, that would prohibit or require, or why does it require schools using the same certified person to require multiple checks? For example, I'm a coach in school A, a teacher in school B, and I wash windows there on Sunday in school C. I still have to have from all three, although I'm a certified, been cleared once.
In one, yeah. And I don't have a real good answer for that. There may be somebody in the room better suited to answer that question for me or for you. I guess it's a function of who's vetting the candidate. And I think as it stands now, that's on a district level for some things, and certainly the school administrative unit for others. So I think it's a function of maybe aligning those two things to allow for that flexibility. But as it's written, my understanding is that authority to vet a candidate for a particular position or role in the school comes from that building administrator or person responsible for that facility.
May I follow up?
Yes, go ahead.
Thank you, Chairman. So based on what you just said on who's vetting it, if they're all vetting for professional functions within the school, athletic department, phys ed department, science department, and 3 different schools, so they're all vetting for a school district, would the background check that your organization does be the same background check because they're all school district, or would it be something different for each one?
No, the process is exactly the same. It's just a function of when the check is done. So for example, you could have somebody that's got a clean record today, but tomorrow they commit a crime or get convicted of a crime, and then you've got however much time passes, so the record would be updated and refreshed. So the process is exactly the same for all of those units, if you will.
Okay.
But it's just a function of, again, it's what it is today may not be what it will be tomorrow.
Okay. Thank you, Mr. Chairman. Thank you, sir.
Further questions? Yes, Representative Nelson.
Thank you, Mr. Chairman. Thank you for taking my question.
Yes, sir.
What, do they review checks on teachers or someone doing something like this? So if I'm a teacher and you run the background check, I'm all set. But do you go over like every year to check it out to make sure I haven't done anything bad in between?
We do, the Department of Safety doesn't do that. We simply provide the record pursuant to statute and rule to whomever that body may be, the school administrative unit. So we're just the keeper of the record and the disseminator thereof.
Other questions? Over there, Representative Porter.
Yeah, but I might know the answer already, so I'll be brief. So the records that you send out to the school districts are detailed records?
Yes, ma'am.
They're not just superficial?
Correct.
Okay, if you were to send those to, say, the Department of Education, and they looked them over, could they only send a passed or failed to somebody, or would they be required, do you think, to send the whole record?
From our standpoint, it just depends on the law. It depends on the FBI. It depends on the law. We're happy to do either, I suppose. It's just from our standpoint, how the record gets disseminated is of concern. You know what I mean? Because we are at the mercy of the FBI to say, yes, that's okay, or no, that isn't okay. Or it can only be disseminated once versus I disseminate it to you, you disseminate it, further disseminate it. That further dissemination is kind of where the issue lies.
I see.
Or the concern. It's not an issue of mine or ours. It's just a function of, can we do it?
Thank you.
Further questions, Representative Lakis?
Yeah, I do have, I can't see you, yes. I do have a question based on a conversation we had earlier on an earlier bill. And I know you've talked to us numerous times, and I appreciate it.
Yes, ma'am.
Currently, we have this education freedom accounts, and a scholarship organization is the one who runs it and vets the vendors and et cetera. But only government agencies can request and get this information. So the question is, where we're using them to run our government program, are they allowed to do that or not?
Who are you using, I guess is my
It's a scholarship organization that runs the program.
And they're getting a record from the Department of
That's
Safety?
the question. Can they get a record from the Department of Safety? Because we're asking them to vet all of the people that work with the kids.
Yep.
Can they do that?
I don't have an answer to that. I would say the FBI, I think, restricts it to governmental agencies. So I don't know. I'd have to look further
Thank you.
to answer your question.
Are there further questions? Not seeing. Thank you very much.
Thank
Can you
you.
hang loose, though, until we're finished?
Yes, sir.
There could be possibility of something else.
Yes, sir.
I'd like to have Attorney Fenton come up from the Department of Education now. And we've talked about this topic quite a bit here, and but now we have, this issue in this bill right here. Diana, could this be resolved without a committee, just through our doing something, as Representative Waltz has mentioned, just try to get on it if it's that imperative? What are your feelings about that?
Well, thank you for the record. My name is Diana Fenton. I'm an attorney with the Department of Education. I am very thankful to Representative McGuire for bringing the bill forward as it is. She and I had the opportunity to speak. It is the overarching concern, I suppose, is that we want to be mindful of creating, and I mentioned this earlier today, the infrastructure by which the department takes on this role. The department is fully capable and able to take on this role, and we have done so with the implementation of bus drivers and first-time teacher educators. However, I will just reiterate that I think we just have to be mindful of allowing the department the time to get this up and moving and work out all the kinks. My hesitation is simply this. If we move too far too fast, children are harmed. Period. And no one in this room is okay with that. Is it something the department can take on? Absolutely. It is a role that we are willing and able to take. In fact, I will share with you that when Commissioner Edelblut first started, and I shared with him my vision for the department running teacher applicant records, Commissioner said to me, well, yeah, let's do that. Let's get it done tomorrow. And I said, well, let's just slow it down a little bit. And so we have worked quite extensively to create this program legislatively. We have worked tirelessly with the Department of Safety because, as you've heard from that testimony, those federal regulations are complicated, to put it mildly. So it was in discussing this with Representative McGuire, I said to her, is this something the department can do? Yes, absolutely. It is a function they can serve. But when we start looking at this issue, it is a Pandora's box. It is a slippery slope. And you're going to quickly recognize, and I think Representative Tanner, you had the opportunity to dip your toe in this pool a little bit, and you were wise, smarter than me, and you pulled it right back out. It becomes a Pandora's box. Because one group says, well, I go from school to school to school, and another group says, yeah, I do too. And so all of a sudden, we have a bit of a quagmire on our hands, and I think we have to be very mindful of the role the department plays, and again, always putting child safety first. I think it would behoove us to have a study committee
I know sometimes it feels like we're kicking the can down the road, but I think in this particular instance, it would best be served to have those thoughtful conversations, not only with the Department of Education, but with our partners at the Department of Safety, to really look at what this looks like and how it will play out. Because a couple of things that the lieutenant mentioned is that having stale records, and we also have to recognize that when we look at the statute, 18913A, which is always our guiding principle in this particular area, those set out a limited number of offenses which prohibit employment, absolutely prohibit it, and that is clear across the state. But each district is given discretion to say, I can decide for my district, for the particular position in front of me, if that record is going to work. So they have a lot of discretion. So we have to think very carefully about the role the department would play and whether we want to take that discretionary ability away from the districts. And it's a balancing test. So I think it is a very complex topic when you start peeling back the layers, and I know Representative Tanner would agree with me, although I rarely speak on behalf of people. And so for those reasons, I would suggest that that this committee establish a study committee. I think Representative McGuire's approach is appropriate, given the complexities.
Thank you very much. I agree with you on that. As a past administrator, I know that the district over here, the superintendent would receive something, I would receive something, and both were dealt with differently. And so we have those lower levels of those agencies, reacting differently towards certain situations. So this is a difficult topic to bridge.
It's a great topic to talk about.
Yeah.
But let's
Well,
let's take the opportunity to look at the infrastructure we create with first-time educator applicants. Those rules are just going into place next week at our next board meeting. And so we need to start issuing those and running those records and reviewing those records as a department and see, it's inevitable anytime you take on a new task that there will be bumps in the road. And we are aware of that, and we're willing to work through those. But I would like to work through those in a smaller chunk and work out those issues than in a bigger, heavier lift. Again, because at the end of the day, if there is a misstep, it's child safety. And I told the commissioner when he started in 2016, I'm not okay with that, and I stand before you with the same testimony today.
Further questions? Yes, Representative Cornell.
Thank you. Thank you for taking my question. You mentioned stale records, and I think this goes back to Representative Nelson's question. Once somebody goes through the check and they're okayed, do they get checked on a regular basis, or is that it, unless something's like in the newspaper?
Right. Thank you for the question. And the minute I said the words, I recognized that I was speaking in code, and people probably thought I was talking about bread, so I apologize for that. So in the criminal justice system, if the minute a record is a day old, it's referred to as stale, because it's kind of like buying a new car. The minute you drive it off the lot, the price goes down. The minute a record is a day old, we don't know anymore. So currently, in terms of employment, if I work at a district and I was fingerprinted when I started, back in pick a year, I do not have to redo that background check if I stay at that district. I will only have to redo that background check if I go to another district. Again, it's an issue of employment, and that's when that comes up. So yes, we have educators in the state who have been employed at a district for 20, 30 years, and they've been subject to a background check one time.
Representative McGuire, you have your hand up here. As maker of the bill, come on up and sit.
Yes, thank you. I don't know about education, but many of the professions have a requirement to renew one's license that you report on any criminal history that has happened since you last got your license. So that if a speech language pathologist is licensed for 2 years, every 2 years they will report to the board that they have not committed any crime that would invalidate their qualifications for working in schools. I don't know about teachers as much.
I do.
You don't have to put your hand up.
Thank you. So thank you, Representative McGuire. Under the Code of Conduct, if a teacher is arrested for a Section 5 violation, they have an obligation to report that arrest. It is not for any and all arrests. So, for example, a DWI, which is not a Section 5 violation, would not have to be reported to the department. Presumably, the district would find out about it one way or another, but that might be an issue of employment. I would imagine that most districts have an employment policy that would require that someone report if they have been arrested. But that is going to be a district-to-district employment-only decision. The other topic that Representative McGuire brought up that I would be remiss if I didn't address is the idea that a lot of professions that are going into various school districts, such as speech-language pathologists, nurses, things like that, we have to be cognizant that they have already gone through some type of background check for their license. Lawyers, we go through a background check, and so we can look at those entities very carefully to make sure that we're not being redundant in our practices, and also to make sure that nothing's falling through the cracks. So when we look at schools, and I mentioned this to Representative Litchfield in the hallway, schools were designed and envisioned to be open, welcoming places. They were, and it's wonderful. And now we're recognizing some of the pitfalls of that policy, and so we're trying to tighten something that was designed to be open and welcoming. And so we have to do it in a very thoughtful, conscientious manner, as we recognize the number of people and the different types of people who go through the school doors.
Are there any further questions of the department? Last one from myself. We've talked about several bills dealing with criminal background checks. If we form a committee here, would it be wise to fold some of those other issues into this study, or should this remain unto itself?
At the end of the day, that is a decision for this committee to make. However, I will say this, because that's a really dirty lawyer answer, isn't it?
Yeah. Yeah.
Is this being recorded?
I'm going to get our own lawyer on top of you here.
I know. I'm hoping you don't call on her. Yes, it is a great idea to look at all these issues. My hesitation in my answer is simply this. I had a wonderful opportunity to work with Representative Tanner on a similar study committee, and what we found was it was overly broad. And again, I don't want to speak on behalf of Representative Tanner, but my experience, my takeaway from that was I think we would have been better served if we had narrowly tailored it to one or two issues. The minute we started talking about this, it was so big and it was so broad that we really kind of stumbled over our own feet, if that's fair to say. And so, yes, I think there is an opportunity to talk about this in a broader picture. My only caveat and word of warning is once you get started down this path, you're going to find that the octopus has a lot of arms. So do with that what you will. And no one wants to chair that committee, I can tell. Everyone is going, not me, not me. So yes, I think it's a great opportunity, but it would only be successful if the Department of Education's there and the Department of Safety.
Well, we've already had Representative McGuire say she will chair it.
Perfect. I think I heard that as well. So.
Yeah, I agree. Okay, are there any other questions for the department? Not seeing any. Thank you very much.
Thank you for the opportunity.
Do we have any other cards, or is that? No, yes, that's it. Anybody else there on this bill? Can you get a card done if you haven't done that?
For the record, my name is Roxanne Chester. I live in Bedford, New Hampshire. I'm not speaking to this bill either opposed or support. I'm just bringing up a little bit of education and understanding as to what something like this, I think. So initially I came in thinking that I was opposed to this because that means spending money. But after hearing the the representative who sponsored this bill, the prime sponsor for this bill, I think that it is really important to think about looking into this and diving into this a little bit closer. Would you believe that more than 7 of the people that have come into my children's school to do story hour or to volunteer have a criminal record history that I would be extremely worried about them being in my classroom? That's it.
Thank you very much. Questions? Thank you.
Thank you.
So not having any other pink cards up here, we're going to close this hearing and thank those that came. Thank you to the department for showing up and offering your input, and also to the other department, the education department. Okay. Okay, the next bill we have is 1198. This bill is relative to rules of the Department of Education concerning culture and climate in schools. Get to the right page here. Let's see, we're supposed to start this at 2:15. Yeah, we got, well, no, we're good. Yeah. Yeah, it's like watching. Yeah. We're all over the road, yeah. So, Representative, you're here as the prime sponsor of the bill. You have the floor.
Thank you, Mr. Chairman, and honorable members of the committee. My name is Greg Huff. I represent Belknap County, Laconia. And, you know, if it has any bearing at all, I was a classroom teacher once. The purpose of this bill is, there's a couple of pieces of this, and I'll try and be brief, and I only plan to talk for about 5 minutes, if that, so please hold me to it, because I can get off on a tangent. I'm sure you folks don't want to hear any of that today. What this bill does is all of our agencies have the ability to create administrative rules. And these administrative rules have the effect of law. Basically, they are. When perusing through the education laws, administrative rules, it's in pretty much chapter 300. It goes chapter 200, but 300 has many different pieces of it. 302 is duties of school superintendents. 300, by the way, is titled Administration of Minimum Standards for Public Schools. And then it goes on, it outlines things of like school boards, principals, duties, things that, construction of schools, development of appropriate daily activities. But there was one section in here, and it's in 306, that said minimum standards for public school approval. And when I got into that, I noticed 30606, and 30606 was culture and climate. What grabbed my attention is the ambiguity of it. Typically, as an educator, I learned pretty quick that there's a language that's spoken amongst those who are in the education field. I used to call it eduese. I don't know if it's still called that anymore. It's basically a way to put a word salad together with a lot of very, very good words that basically don't amount to much. And that's what this climate and culture thing is in this particular section of the administrative rules. There's two parts. One part deals with what the school board is required to do or shall reflect in their policies. One is acknowledgement of diversity and respect for differences. I'm going to start on that. First off, if you go to the beginning of all of these administrative rules, they have definitions. There are no definitions for diversity at all in this, or what differences are. I know what the intent is, and the intent here is to go on the same four things that are always the diversity argument. Generally, race, creed, sexual orientation, religion. But diversity is far, far more than that. Diversity could be intelligence. Diversity can be shoe size. Diversity could be the proclivity to like a particular color or an athletic ability. There's zillions, literally countless ways to be diverse. My point is that this is hamstringing your educators because they have to follow this stuff. Okay, there's a few other things in here too that are similar. I'll give you one of my favorite ones here. Where is it? Respectful use of language and behavior by all school members that is void of ethnic, racial, and sexual stereotypes and biases. Sounds great. Our schools are failing miserably when it comes to education. I think climate and culture is not something that actually needs to be in this type of a rule. Your schools are more than capable on that particular one. Respectful use of language. I'm pretty sure all school teachers demand respectful use of language. This is not something that needs to be in here. It's an overreach, and the overreach comes from a system whereby us, the legislative body, has abdicated their authority in creating rule of law. We've done so by giving administrations the ability to create what they want. Most of the time, they do a pretty good job. Sometimes they don't, and all of the time, they're not accountable to the people of the state. So, in this instance, the only way that I could go after this is I can't, or we can't, do anything about what the administrative rules are that they decide are going to be. It either has to run out, because they go, I believe, in blocks of 8 years currently. They either run out and are not re-upped, or they're rewritten at that point, or they just can be continued. Unless we dial back what it is that they can do, which is what my bill does. That's why there's really no mention of the actual statute. That's in the education thing. That's a 30606 if you want to actually take a look at that. It comes from the powers that's mentioned in my bill of school board, state board of education, the powers that they have. That's under title, I believe it's 15, Education, Chapter 186. This particular one is 186.5, and I just want to quickly just go over a particular little piece of it. It's a small section, and I won't bore you with the whole thing, but it says, it may make all rules and regulations necessary for the management of its own business and for the conduct of its officers, employees, and agents, to ensure the efficient administration of public schools and the administration of the work of Americanization in teaching English to non-English speaking adults, and in furnishing instruction in the privileges, duties, and responsibilities of citizenship, which is hereby declared to be an essential part of public school education. Climate and culture. I ask anybody here to define that specifically and what that has to do with teaching children how to read, write, think properly, any of this stuff. So that's basically it in a nutshell. I'd be more than happy to entertain any questions any of you may have of me, and I'll do my best to answer them.
Thank you very much. Questions, Representative Luno?
Thank you very much, Mr. Chair. Did you do any research before writing this bill?
A little bit, yes.
Follow up on that?
Yes.
Did you research the expiration of administrative rules?
Yes, they generally expire about every 8 years, I believe, currently.
Right. And then the final thing is, where did you research and come to the conclusion that, quote, schools are failing miserably when it comes to education?
That one pretty much comes from my hometown, where the actual proficiency rate is, I believe, 32%. So 32% proficiency rate of children that are actually on grade level with reading, writing, and mathematics, which means 66% are failing.
So follow up, would it be fair to say then that when you're talking about schools are failing miserably when it comes to education, you're talking about the schools in the town you are from and not a statewide phenomenon?
No, I'm talking about a statewide phenomenon.
Yeah, that's just.
When to clarify, when I say failing miserably, I'm saying that academically and achievement-wise, they're not where they should be. And things of this nature, which are absolutely useless, are involved in hampering our educators from doing what it is that they are supposed to be doing. I hope that answers your question.
Representative Mullen?
Thank you, Mr. Chair, and thank you for taking my question.
Yes.
Did you talk to anybody at the Bureau of Student Wellness at the Department of Education?
I did not.
I think you might want to, because they've done a significant amount of work around climate and culture through the Department of Education. And I think that they might be able to clear up some of the questions that you have about the usefulness and appropriateness of looking at the climate and culture of a school building, because I think there may be more than one way to define climate and culture, and I think that you may only be looking at it from one perspective.
So the question?
My question is, have you spoken to anybody at the Bureau of
No,
Student Wellness?
I haven't. And as far as climate and culture goes, you're absolutely right. It can mean many, many different things. The part that I have a problem with is the culture is American. We're all American. We all live in this country. That's our culture. There shouldn't be a subculture being taught in the schools. And that's what I'm trying to address here.
Representative Lakes?
Could a climate of honesty and a culture of learning be a climate and culture that we might want to have in our schools?
Oh, absolutely. You have to understand how I had to have this written. I can't specifically pull out pieces of the administrative rule. The only way that that can be done is by this broader stroke of the brush. I would much rather just have some of the, because to be honest with you, there are, in that small little piece of the administrative rule, only about half of it do I actually have a problem with. The other half is inconsequential or fine. But after going over and over and over, my options to be able to take things out, okay, the language was terrible. In other words, if I can just give you a quick example. Let me just quickly find this here if I can. Okay. If I wanted to have the acknowledgement of diversity and respect for differences taken out, and don't get me wrong, that's fine. I just don't think it should be a priority to be taught. We're all different. It's a given. Everybody in this room is different. It's not something that needs to be dwelled on or harped on. The point is if it was to be written to take that out, it would sound something to this nature. It is not applicable for a school to be able to adopt a policy that is favorable to diversity. And you see what I mean? Yeah, that's the face I made. I'm like, there's just no way that you can write something like that. It sounded absolutely horrible, and it didn't really meet the purpose of what I was trying to accomplish here. I hope that answers your.
I understand that.
I have a question for you. I'm looking at the minimum standards for public school approval right now, underneath 306.06, culture and climate.
Yes.
And one of the statements in there says the school administration shall provide professional development opportunities, great, directed at understanding the policies and reporting requirements that support a safe and healthy school environment. That's under the section that you're talking about.
It is.
There's other sections, review ways in which equity gaps in achievement, which we're constantly on this committee dealing, how we close those gaps that we have on our statewide assessment, and can be reduced, and barriers to learning can be eliminated. As I read the statements, whether it's in A, B, or C underneath what you're calling the culture and climate here, and which is identified as culture and climate, I guess I need some help here in understanding why these policies that shall be adopted by the local school board or school administration and staff or school administration are contrary to what we should be doing in schools.
There's a lot there. I may have to ask you to repeat, but I'll try to answer you in the order that you asked. The school administration shall provide development. That was one of the ones that I had mentioned earlier that was fine as far as I was concerned. The thing also that you, if you do peruse through all of this, literally almost everything that is in this particular piece is covered somewhere else in all of the education. They cover health, they cover well-being, they cover personal development, they cover all of these things. This is a redundancy, basically. As far as work together in a fair and equitable, which one was it? Code of conduct? Code of discipline? Is that the one that you mentioned?
I read one.
A review of equity gaps in achievement.
Yeah,
that was the
school
one.
administration and staff.
I'm going to say something that's not popular. Everybody's different. If somebody is smarter, they're smarter. If somebody is not quite as smart, that happens. You can, obviously you're going to try and educate everybody as best as you can, but equity is not the opportunity. Equity is the outcome. If you're trying to make everybody have an equal outcome, that means those who are very, very high achieving are going to have to be pulled in, and those who are very low achieving are going to have to be brought up. Otherwise, leveling everybody's ability. And I think one of the things that I remember when I was a teacher was we don't teach to what is fair for everybody, we teach to what everybody needs. So in this particular instance, I would take issue with that entire thing, is it does not go to the actual support of people learning, it goes to the support of people learning all at the same level. And I disagree with that.
Further questions, Representative Woodcock.
Thank you, Chairman Ladd. Good afternoon. Thank you for taking my question.
Thank you.
As I'm reading the bold section of, bolded, I guess, section of the proposed bill change.
Yes.
I'm taken back when I get to the part that says, any rule requiring schools to adopt a policy concerning culture and climate, because you're talking about prior to that, shall not adopt. Would you, if I may have some leniency or some latitude here, Representative Ladd, would you say that climate would include bullying?
I don't know what would be included in that. I think I know where you're going on the idea of you want to protect the children. You
No,
don't
I just
want
want to know if you think bullying's in climate.
I wouldn't.
Okay, so bullying is not there. Would discrimination be there?
I don't hypothetically. No, it's not there in there.
So discrimination and bullying, those are not in climate items in the school.
I don't see them in there, no.
Okay, would they be in the culture of the school?
I don't know that they would be in the culture of the school. I'm not really sure where you're going with this.
Well, what I'm trying to discern is things like bullying and discrimination would seem to be in the culture of a school. You are prohibiting school boards from adopting any policy concerning them.
No, I'm not.
It says right there. Shall not adopt or enforce any rule requiring schools to adopt a policy concerning culture and climate. So I'm asking you,
Correct.
what's in there?
Correct. Culture and climate in here. None of what you asked me of is in here. All of what you asked me of are currently illegal already. So it's not a question. It's somewhere else. Like I said, this is redundant.
If I may, Chairman Lott. So my point is,
Yep.
or was, if you have school board policies
Mhm.
that deal with discrimination or the ability not to discriminate,
Yep.
or if you have school board policy to deal with bullying or rules and procedures in the school not to bully, because they all impact the climate and culture of that schoolhouse, Your bill, as I see it, says that those should not be there.
I see where you're going. Okay. That's not the intent of what I'm doing here. Obviously, I don't want this to hamstring, stop, or curtail any particular school or school board from doing what they deem appropriate for their children and their area. So that's not the intent of this. I don't believe how this was worded was to keep it from adopting those policies or agreeing on those policies. This is supposed to mean that the Department of Education will not require it or enforce it if it is not there, if that makes sense.
One more. Last one.
One more.
Thank you, sir. Well, I guess my point is that's not what it says. And I think you'd be hard pressed to go into any school in this state and talk to any teacher administrator and ask them if they believe that bullying and discrimination are not part and parcel of the culture of that school, and that there needs to be school board policies that are enforceable to create a better culture and climate in that school.
Again, bullying is illegal, and it's in every handbook, pretty much of every school, that you can't. So I understand what you're saying, and I don't want the restriction. If that is the opinion eventually of this committee, I'd be more than happy to have the wording changed so that it doesn't do what you're describing. Okay?
Thank you. Thank you, Representative Ladd.
Thank you.
You're welcome. Further questions from the committee? Not seeing it. Thank you. Yes, Representative Moffett.
Thank you, Mr. Chair. I'm trying to understand the intent here, and tell me if I'm understanding it in this way. You don't want to preclude, let me put it this way, you don't want to see the state board or DOE favor, I'm trying to think, what you don't want to see happen is the state board or DOE promoting or supporting values or approaches that don't have community consensus support. Is that
Yes.
kind of what you?
Yes, and I'll explain it in a hypothetical. Okay. The climate and culture section here seems to be a redundancy and a catch-all. And the reason it makes me uncomfortable is because it has been adopted by a bureaucracy. That bureaucracy theoretically can change. Tomorrow, climate and culture could be everybody has to wear a mask. Tomorrow's climate and culture could be everybody needs to adopt a squirrel. Do you see what it's just an arbitrary thing that was put in here. It didn't get, there was no hearing like this to discuss the merits of it. When you go into GELCAR, and this is my understanding, I'm learning these things for this, but from my understanding is GELCAR doesn't really do anything as far as what the rule is. They just want to make sure that it is proper and crosses the I's and dots the T's. They don't have the ability to say, no, this is bad, we're taking it out, or this is good, or we should amend. So to work on this was the only avenue that I had.
Yes, thank you.
Further questions? Not seeing. Thank you very much.
Thank you, Mr. Chairman, and thank you, honorable members of the committee.
Okay, we have Holly Stevens.
Good afternoon, Chairman Ladd and members of the Education Committee. My name is Holly Stevens. I'm the Director of Public Policy for NAMI, New Hampshire, the National Alliance on Mental Illness. NAMI, New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted affected by mental illness and suicide through support, education, and advocacy. And on behalf of NAMI New Hampshire, I'm here today to speak in opposition to House Bill 1198 relative to rules of the Department of Education concerning culture and climate in schools. So I know there's been a little bit of discussion about what climate and culture are. The governor had put together a task force on school safety that came out with a report in 2018. And in that report, and it is available online, and if anybody would like, I'm more than happy to send the link to it. A school's culture is the set of norms that defines the behavior inside the school and largely determines what is considered socially acceptable behavior between classmates and between staff and students. Culture is significantly important to the social, emotional, and academic success, health, and social emotional outcomes. A positive culture in a school, if a school has a positive culture or a negative culture, it's a great predictor of dropout rates, absenteeism, truancy, suspension, drug use, violence, and aggressive behavior. And positive school culture is closely associated with pro-social motivation, academic motivation, self-esteem, conflict resolution, and altruistic behavior. Additionally, positive school cultures have been linked to, as Representative Woodcock alluded to, a reduced incidence of bullying among students. And what the task force found was that bullying in a school, the increased amount of bullying in a school is one of the main predictors of student violence. And a 2010 study correlated a student's perceived sense of security, which is also part of the culture and community, having a safe environment. If students felt safe in their culture in the school, there was an 18% increase in student score performance. So the culture and climate is directly linked to academic performance as well as social and emotional well-being. And as mentioned about the bullying, not only is it associated with violence, but it's also associated with high levels of suicide-related behavior. There's no direct causal link, so no one's done a study that says, yes, this child was bullied, there was suicidal behavior. There's not a direct link. It's a correlation. But what they have found that involvement in bullying, if the child has other risk factors, it increases the chances that the young person will engage in suicide-related behaviors. And I have provided the citation for that study. Currently, in New Hampshire, suicide is the second leading cause of death for young people and young adults ages 10 to 34. So any action that New Hampshire can take to reduce the incidences of suicide and violence among young people is incredibly important. Our state has a vested interest in assisting the schools in cultivating a positive, safe culture and climate throughout each school system. House Bill 1198 would prevent the Department of Education from doing this important work. And so for these reasons, NAMI New Hampshire requests that the committee vote inexpedient to legislate on House Bill 1198, and I will take any questions that the committee has.
Thank you very much. Are there any questions from the committee? Not seeing any hands. Thank you very much.
Thank you.
You're welcome. Next card which we have is from New Futures, Emma Savigny.
Good afternoon, members of the committee. Thank you so much for having me. I'm here, my name is Emma Savini. I represent New Futures. I am the Children's Behavioral Health Policy Coordinator there. New Futures is a nonpartisan, nonprofit organization that advocates, educates, and collaborates to improve the health and wellness of all Granite Staters. New Futures opposes this bill because it may erode the progress that our state has made toward implementing the multi-tiered system of support for behavioral health and wellness, commonly referred to as MTSSB, a critical part of our system of care that creates a positive learning environments for all students. MTSSB is an evidence-based comprehensive system of social and behavioral and emotional supports to promote student wellness and improve engagement in learning. It's a three-tiered system. At the bottom of the kind of pyramid, if you would imagine it, tier 1 are interventions that a school can implement to improve the social and emotional wellness for all students. The second tier, which represents fewer students, is interventions that the school can implement to improve the wellness and social wellness of students who need more severe interventions. And then at the top of the tier, tier 3, are interventions that the school implements for students who need more intensive treatments and interventions that to improve their social and emotional wellness. The culture and climate of schools and MTSSB form almost a cycle in creating a positive culture and climate in schools. A positive culture and climate lends itself to proper and better MTSSB implementation, and then implementing MTSSB then increases the positivity for culture and climate and a better learning environment for all students. If passed, House Bill 1198 could erode the progress that we have made so far in implementing MTSSB. The rule cited by the bill sponsor, Rule 306.06, is the minimum standard for culture and climate that gives kind of the basis for MTSSB implementation. Eliminating this rule altogether would remove that minimum standard, and therefore schools would be less likely to implement MTSSB. Schools provide students with much more than just an education in the traditional sense, like reading and math. Schools are really important for students to get a foundation in social and behavioral learning so that they can be successful later on. The culture and climate in schools is crucial to providing a safe and healthy environment for students to learn how to interact with other peers and their teachers and administrators. Especially with COVID, where it's an extremely tumultuous time, programs like MTSSB give students a healthy way to learn how to cope with large changes and major stressors in their lives. By removing the minimum standard for a culture and climate in schools, this MTSSB and other similar programs will be less likely to be implemented, and schools will no longer be the safe place for students to foster social, emotional, and behavioral learning that they need to grow into successful adults. For those reasons, New Future strongly urges the committee to vote House Bill 1198 inexpedient to legislate.
Thank you very much. Are there any questions for New Futures? Yes, Representative Cornell.
Thank you. Thank you for taking my question, and thank you and Holly for reminding us that this came out of the governor's school safety task force, and that's what this is a result of. Well, my question is, from what I understand, and I may be wrong, the Department of Wellness works with school districts across the state to implement MTSSB or something similar on how it fits into each particular district. So it could be a huge program in one place, in a small program in another place, depending on what is decided on by the community. I'm pretty sure there's community input into these plans, and it's not just something that's thrown in. I think it's actually Merrimack that worked on it for 5 years before they started implementing something. And they worked with the community, they worked with the schools, they worked with businesses, and then they implemented what fit best into their school district. And I think that's what is going on in the state now. Little by little, they're working with areas. So taking this out of it would, undo a lot of the work that's been going on in the state. Am I right?
You are, exactly. Thank you so much for your question. The the steps are exactly as you described. The community and the school district determines that they're going to take part in MTSSB. There's a period of time where the school determines what types of interventions the school needs, what can they improve in their culture and climate, and then it's an ongoing process of refining and ensuring that their interventions they're putting in are working. They check data to make sure that the interventions are working and reaching those goals that they've set.
Thank you, and I'm sorry that the sponsor didn't stay to hear all that.
Further questions? Not seeing. Thank you very much.
Thank you.
Hussein Chester?
Thank you, committee chair. Thank you, committee members, for allowing me to speak on this. I just want to start by saying that although I'm a Bedford resident now, oftentimes when I'm speaking for when my children are in school, and they were not always in the Bedford school system. So I just wanted to make sure that I clarified that, so I'm not bashing my school district that I currently live in. However, what I will say is that I listened to what the representative, or what the director for public policy with NAMI had to say, and with regards to what New Futures had to say. And my concerns is that what is happening in our school system, yes, we have MTSSB, and I think it's been hijacked. I think that what is happening now is there's a culture and climate that's going on in our school districts that may be put in place by the school boards and not necessarily by the community standards that the constituents that voted those people into office really understand what's going on. For instance, in Bedford schools, Bedford schools specifically, but I just checked a couple of other schools districts too. Would you believe that prior to adopting MTSSB, the amount of suicides was much lower than it is today in the few school systems that I checked? Would you also believe that in the school systems that I checked, and I'm more than willing to provide you with this information, like I said, I was sitting back there and spending a lot of time looking things up. Would you also believe that right now in Bedford, New Hampshire, there is a program for students in our high school that allows for kids to talk about maltreatment? There has been a couple of canvassings done of those students. 1 out of 5 of those students that have identified bullying or inappropriateness or anything to that effect, suicide ideation, would you believe that 1 in 5 say they were not a victim, but they were basically bullied into identifying themselves as victims? So that's the problem with MTSSB, and that is what this bill is trying to combat. So I believe strongly that discrimination is discrimination. Culture and climate should never be, that should not be something that we have to talk about. Discrimination is discrimination. So the bottom line is if you have a history of abuse and neglect, and your other child does not have a history of abuse and neglect, they should not be identified differently. And the more inclusive we try to become, the more diversive we are that's happening to our government, our children. Thank you.
Questions for the presenter? Yes, Representative Cornell.
Thank you. Could you please tell me how you got people's private information on how they replied to the surveys? When you said 1 in 5 admitted that they were bullied into giving the answer that they gave, how do you find that out?
So there's a Facebook group. There's a Facebook
Never
group.
mind, thank you.
Well, no, it's just the children have said that. Okay.
Further questions? Thank you. Are there any other cards for this particular bill? Not seeing any, I will close this hearing. Jeez, I can't believe, he might be trying to say something, but he's saying it the wrong way. You know, I have a daughter, a granddaughter, who was chased out of the school, and that's why she went to St. Jabe, because she was bullied. That was the culture of that athletic program she was in. You know, if you were the top dog, go after the top dog. Then when I was in Alaska in Kodiak, the high school there had a reputation of having gangs in it and fighting. That was the culture of that school. That was the climate of that school. So we want to put in place a climate which is contrary to that, and we do it through our board policies. And everybody being on the same page. I'm sorry, I think that was way off the deep edge.
I'm not sure where he was going, but I think wherever he was going, he's going wrong.
Yeah, good, thank you very much. We got your assistant coming up, huh? Not everybody has a lieutenant colonel as their assistant. General. Yes, yes, yes.
That's your husband.
Okay.
So everything's cut up to start with.
But I don't know if you read these things right here. They're pretty broad. They're not
they are.
dealing with.
Yeah.
We
No, I
got
did
shit
look at
going
them.
on in
Yeah.
schools right now, but I.
Thank you, Mr. Chair. Thank you, members of the committee, for hearing my introduction of this bill. It seems like I can't go anywhere in the town of Derry without this subject being brought up. I bump into parents and they're livid. Their kids aren't feeling well when they get out of school. You know, I had a call from a student. He was in the 8th grade at West Running Brook School, and you know, he said that he wears his mask in school. You know, he's forced to. They're humiliated and stuff if they don't, and you know, by the teachers, by the way. And he says, you know, by 10 o'clock or so, he's not feeling well, and you know, he's got a headache. He's got, you know, nausea, stuff like that, and you know, that's not a good climate to try to teach a kid. And he gets home from school, and it takes him an hour for the headache and the nausea to go away. And like I said, the bullying that goes on, you know, almost encouraged by teachers and stuff. And if you think we don't have bullies for teachers in this state, boy, can I tell you some stories, you know. Representative Bowman and I were just talking about it. I experienced it with my daughter. As a matter of fact, my niece, she has a niece through marriage, and you know, and it was because of masks and mask mandates and stuff up in Wakefield. But her niece has biracial children. And this teacher told this woman that she should take her kids to another school district because they don't have any black kids in Wakefield. It's being investigated by the Human Rights Commission right now and in the Department of Education. You know, we do have bullies for teachers, some of them. Most of them teachers are great, but anyway, you know, that's going on at West Running Brook School. I've got I sent this around. It's a letter, an email from the principal at West Running Brook, and he's more or less saying that, well, you know, the kids that won't wear masks, we're going to re-educate them. We're going to have re-education camps on Friday after school. Okay, those aren't his words, but that's what it says. And where have I seen that before? You know, you've also got an email from Dr. Michael Leon, and he's describing the way there is no scientific studies that say masks work. Okay, let me read a paragraph for you. Medical interventions are evaluated based on two criteria: safety and efficacy. Any clinical interventions must be evaluated in the context of both parameters. To date, New Hampshire this has not been the case in New Hampshire. Efficacy has been assumed, and safety, harm, in parentheses, has not been given any serious consideration. The current bill empowers parents, not the teachers, to consider both and make the best decision for their children based on all current available data. He goes on to say that, you know, there are no scientific studies. I was subbing in Health and Human Services the other day, and another doctor stood up and said the same thing. And as a matter of fact, he asked the question, how many children without underlying causes, you know, from the 19 up to age 19 have died in New Hampshire because of COVID? And the answer to that is 0. So why are we forcing kids to wear masks, you know, and suffer through the day, be sick through the day, and be bullied in school? And you know, this is nonsense. Windham just went mask optional 2 or 3 days ago. Northwood did the same thing. Ralph tells me Litchfield did the same thing. My town will not. They will not back off it because it's been such a contentious thing. They've dug their feet in the ground, their heels in the sand, and you know, will not do it. I hate to say the state has to do something about it, but they're overstepping their bounds. There is no law. You know, they have no right to do this. They can't tell a kid he has to wear socks to school, never mind a mask. And you know, it's time to stop. It's time to stop the bullying. It's time to stop the nonsense. Thank you.
Thank you, Mr. Chair. Thank you for taking my question. You indicated in your testimony that I guess this memo from the principal about the Friday class was like a re-education camp.
Yeah.
And you said we all know what that is related to. What were you referring to?
I said we all know where we've read that to.
Yeah, what are you referring
Back in the
to?
40s, there was this guy called Adolf Hitler that used to do that. Okay, he had re-education camps. Okay, you know, here's another piece of nonsense. This was written on the 19th.
Thank you very much, sir.
Okay.
Further questions? Representative Mullen?
Thank you, Mr. Chair. Thank you for taking my question. You mentioned that this is a contentious issue in Derry.
Absolutely.
So would it be assumed then that the school is trying to deal with people who are very upset about the wearing of masks and people who are very upset about the not wearing of masks?
That would be correct, but why is any one group's fear any more legitimate than the other?
I don't have an answer for you for that, sir.
Representative Woodcock.
Thank you, Chairman Ladd. Thank you, Representative, for taking my question. I was looking at the documents you gave us, and the Westbrook Running Brook Middle School, I guess it's a copy of an email, where the superintendent, the principal apparently said, to be clear, this time is designed for students who have chronically not responded to the encouragement, prompts, and support from staff, and is not intended for students whose mask happens to slip below their nose. This 30 minutes on a Friday afternoon with a school nurse. Is it your thinking then that sounds like bullying?
When children are getting sick and they're told they have to do it anyway, yes, it is bullying.
I'm just asking that comment that you made and you submitted in testimony.
like I just said. If children are getting sick and he's going to have them stay after school, yes, that's bullying.
That's fine. Could I follow up?
Yes.
Well, that's only one second question. If the school has rules, wherever they happen to be, and the teachers are required to enforce the rules that's promulgated by the school board, do you feel that that's their job?
The teachers do have to answer to the school board, but maybe the school board needs to be told what they have to do, because they're going on medical. It doesn't exist, okay?
I'm not questioning the validity of the policy.
Mhm.
I'm questioning your statement that the teachers were bullying for following the rules. That's what you said. They were bullying for following the rules of what they did. All I'm asking you, if the school has rules, are the teachers supposed to follow them or not?
A teacher is not supposed to bully, make fun of, and that's what according to that student that called me, that's what they're doing.
Did you find that on Facebook as well, or?
No, I got a telephone call from that.
Further questions? Not seeing any. Thank you very much.
Thank you.
Trying to see the parents we got here.
Oh, well. Do we have any paper towels around? I thought it was reaching. I tried.
Okay, David Kiley. Is there a puddle or something there? I don't know what the.
I won't melt.
Okay.
Thank you for having me, honorable reps. My name's David Kiley. I live in Atkinson, New Hampshire, and I have 3 children in public school. One is currently at the Timberlane Regional School District, and I've been pretty vocal about masks with my school board. Essentially, at the first physically present meeting that we were able to have, that quickly got switched to Zoom on May 20th until the 91A rules were put back in place, I believe June 1st or 2nd. One of the things that that I'm having trouble with, I totally agree. There are a few different studies that the CDC has put up in pre-release until they were taken down relative to clusters and counties in Arizona. They really made no sense. The authors admitted they were crude, and they never were actually released. But there's about 167 studies that show, from the Brownstone Institute, that show that they don't work. You can debate that all you want, none versus 167. Certainly there's different variations of expertise that people need to look at. My concern really has to do with the inability for our elected officials within the school board, as well as the appointed bureaucratic appointed people like Dr. Chan, for instance, who has some things that have been contrary to even statements made by the CDC, such as that without masks we're going to have major problems with spread, even after the Barnstable study that was done in July, where the CDC came out and said, look, these we have spread. It's going to be equal no matter what you do with vaccines. So there's a lot of information that's coming out from experts that are in positions of authority who are meeting with superintendents, and they're telling them one thing, but they can't really back it up. And the only thing that I can say is that from a parent standpoint, when we're being told that we have research and studies that show that masks work to prevent the spread of COVID-19, and you ask them, okay, can you please provide me with that research? Can you show me what due diligence that you performed to make it okay, whereby like in something as simple as Article 2 in our Bill of Rights in New Hampshire, that says we have the right to protect our property and pursue happiness. How can you violate that? And they turn around and say, well, New Hampshire DHHS actually has that research. You'll have to ask them. So I'm not shy when it comes to communicating and calling people in government. I called his office several times, was never able to make contact, and I wrote an email and I asked these very questions. I've been told that you guys have the research, and I get no response, but I am told through in my own discovery is that they're really relying on the CDC, who posts these Pima County and Maricopa County studies on clusters where You got a county that has clusters that is 75% of the population in the entire state of Arizona, and they're being equally compared to a county that has maybe 5% of the population. Now, these things don't make any sense. So my issue, my support of this bill really comes from the fact that I still have yet to be provided from an elected official within my district, from a superintendent, from anyone at New Hampshire DHHS, which shows me that these things actually stop the spread. The latest and greatest from CDC is they put out a new study that says cloth masks are pretty much useless, or the least effective, they say. And then they go into the improperly worn surgical masks, which, as we know, from the side and the space between the nose, that's about 9 miles of distance compared to a ping pong ball. When you talk about airborne particulates. You can go out and you can look at, OSHA has a lot of information. There's plenty of industrial hygienists that have unbelievable information or references to studies. The EPA has plenty of information out there. You're never going to find something where you can prove that these masks work unless you're talking about a respirator, meaning an N95 that has a filtration device on it. And that's if you can keep it clean. Because if you can't keep it clean, it's really doing nothing. So I think if we're going to exchange our right, to have the ability to be animal costumes in, chokers around their necks with leashes hanging off, but we can't let them smile. I think it's really difficult for me to accept the fact that no expert can tell me why they're doing this. And when we have an environment like, hey, the governor says we have local control. When the local control says, hey, we're only following the recommendations of New Hampshire DHHS. And New Hampshire DHHS can say, not us, it's just a recommendation. Really, the parent is left in the middle. Everyone's punting back and forth, and we're the monkey. And I think it's time for this to stop. I think it's time for us to really just knock off the nonsense, let these kids smile, let them breathe. If you don't think there's a restriction breathing, why are you wearing it? Because you're not preventing anything from coming into your lungs, in theory. So I don't really know what else to say other than we should be making it as hard as possible to allow school districts to put these things on, to require these things on the children's faces, in my opinion. We should stop the noble lying and be on with it and move on. That's it. Thank you. Any questions?
Thank you. Are there any questions from the committee? Yes, Representative Waltz.
Sir, have you Googled this to find the studies?
Oh, yes. Yes, I don't use Google, but yes, I have.
Well,
I've read the studies.
I just Googled it, and one of the very first things that came up, would you believe, is a study from Stanford dated September 1st that is peer-reviewed, randomized study on the use of masks. It's jointly with Stanford and Yale medical schools and both medical schools, with a randomized study with hundreds of people showing in multiple sites, showing how the use of surgical masks and other masks have helped limit the transmission of COVID. The studies are out there, I believe, and that's why I asked if you Google it. Would you believe, and I had no trouble finding a study just sitting here while you were chatting, that a professional study from some of the top universities in the country that immediately, as I say, one of the first things that came up, proved that it does prevent transmission.
I would venture to say that using a strong word like prove it would be inaccurate, but I would say that I don't Google because you're normally going to find things that support masking up top. I tried maybe Brave or I tried DuckDuckGo, where you're going to find a bigger population of studies that come from universities as well, like Brown or Stanford, and I think that's probably fair. I haven't read the study that you're talking about, but I will say that I've seen significant bias in Google, and you can certainly look at Dr. Robert Epstein's studies on Google so that you can get a better context of what they're doing with their search results.
You might want to try Google Scholar. That might be more to your liking.
Google is Google.
Thank you. Further questions? Representative Woodcock.
Thank you, Chairman. Thank you, Mr. Cobb, for taking my question. I know at the last speaker we seemed to get off track more for the jargon than the intent of the bill.
Certainly. And I apologize if I did.
No, it wasn't you. You're fine. I was trying to get back to where it's supposed to be. So I know I apologize for getting a little heated. But beyond that, back to the bill. But the bill really doesn't handle your concern of the school board's policy. I know it's kind of tough. Of the school board's policy of masking in any particular school. You may be talking Timberlane, regional, or wherever the district happens to be. That's not what the bill says. The bill, it does in general, but the specifics of the bill talks about if in fact a school has a policy of masking, and you do not want your child to participate in the policy of masking as a parent choice, then you would be allowed to take your child out of that school and place them in any public-private school, it didn't say in the state, but
Sure.
it's in the state, at the cost and transportation of the school. Right. For example, you could take your youngster out of your home school, if you didn't agree with the policy, and send him to, say, Proctor or Brewster or Wolfboro Academy, or to a private school, or to, another public school down the road from where you happen to live. Sure. So that's the essence of the bill. So your concern about the policy is justified in terms of the local school board doing things you don't particularly care for and how you remedy that. But the bill talks about just moving a youngster from one school to another, whether it be accepted by another district or a private school. Now, do you think that policy is sound?
To answer your question, I think it is. I think if you go back to Article 2 and you talk about the equality of rights, and if you have a school board that is preventing, your right to express yourself through smile or breathing, or maybe even access to an education, however we want to define rights, it fits. I would say 100% that, not only do, as you said, I started out by saying, I think that this is a difficult thing for parents to accept without due process. But I also agree that the incentives that are in this bill make it possible to provide an equal access to not having to wear a mask for whatever reason you see fit, including your access to an education. So yes, I do.
Okay.
I think.
All right. Thank you. Thank you, Ms. Platt.
Pardon me? Okay. Another question, Representative Cordelli?
Thank you, Mr. Chairman. Thank you for being here. I was just wondering if your school in Atkinson has a mandatory mask policy, and if they provide for exemptions, for instance, medical exemptions, or even exemptions for students with an IEP or 504 plan.
I can't speak to that. I can say that I'm aware that they re-implemented that for this school year. They didn't last year, which I think they admit was a mistake. The only thing I can tell you is that I have friends that have kids who that is not always being honored. Even doctor's notes are not always being honored unless they fit certain definitions of disability with respect to services being brought on by the school. But I'm not an expert, so I apologize. I can't really give a clear answer.
Further questions? Thank you very much.
I really appreciate your time, everyone. Thank you.
Thank you. Deborah House?
See, I have this on and you can hear me? Thank you. Good afternoon, Chairman Ladd and members of the committee. I'm Deborah Howes here from the American Federation of Teachers, New Hampshire, and I appreciate this chance to address the committee on HB 1588. I'm here to oppose this, and the main issue is because it is a matter of local control. We strongly feel that this would be the state getting in the middle of a decision that is really best left up to local school districts, local school boards, to all the parents and the voters in a district. Well, this bill is written to give individual parents the right to object to having a student wear a mask in school. It has deeper consequences because removing those students to other educational options, which is the remedy suggested in this bill, could have a huge cost to the district, and that has an impact on the education that is offered to all the rest of the students that are in those public schools, to all their families who choose those public schools and support them, and to the local voters and local property taxpayers. I wish with all my heart that we weren't still in this place in the pandemic where we're having to talk about masks and other mitigation measures so that we can keep schools open. I would really like, and all my colleagues would really like, to be able to teach and see our students face to face and see their whole face, not just this part of it. But we need to do what we can so that we can keep schools open and in person. And I understand how strongly people feel on both sides of the mask issue. But having the state step in like this will not make it any better. New Hampshire has a long tradition of local control and local democracy that gives parents and educators a voice in schools and communities through their local school board. This bill inserts the state into safety decisions that should be left to families and communities to work out with their elected school boards. And as I was saying before, the budgetary impact on a district could be huge because the remedy suggested is that a parent who objected to a locally adopted mask mandate could send their student to any other school, public or non-public, or in any program that was approved under the existing state voucher program. That could be a small cost, that could be a large cost, depending upon what the program is, what the school is, how far away it is. The transportation would also have to be borne by the sending district. That could very quickly add up to needing to cut your budget. That would very soon, mean that you're looking at cutting classes, you're looking at cutting staff. That is not fair to all the other students, all the other families that are depending on that public school. So if we're talking about balancing rights, you're balancing the rights of the individuals who object versus the rights of all the other students and families relying on that public school. This new bill is an unfunded, unlimited mandate on local school districts and property taxpayers. Why would we put this financial burden on our neighborhood public schools at a time like this? Schools and educators are doing their best to give students stability, help, hope during another challenging school year. We need support from this legislature. This is not the time to drain even more funding and resources from our schools. This is not the time to create more chaos. It's time to be pulling together and doing what we can to make this a year of recovery for our students and to do what we can to help them all thrive. And I thank you for your attention, and I do have written testimony that I'll pass around.
Thank you very much. Are there questions? Representative Bohm?
Yes. Thank you, Mr. Chairman. There are a lot of laws on the books that tell school districts what they can and what they cannot do. So what would be the cost if all the school boards have to do is follow the law? Then there wouldn't be any cost.
The cost would be in having to send a student to any other school or educational program in the state and pay for the transportation and the tuition. That would be the cost.
But wouldn't, follow up? But wouldn't there be no cost if the school district just followed the law, if this became law?
I believe I've already answered your question in the only way that makes sense. The transportation is not costless. Tuition is not costless. So we could play a logic game if you'd like, but I cannot answer it differently.
Further questions? Representative Cordelli?
Thank you, Mr. Chairman. Thank you for being here. I was just wondering if you might know from your discussions with your members in schools where they have mask mandates currently, do schools provide for exemptions, for instance, medical exemptions or exemptions for children who've been vaccinated or who might have natural immunity from having already survived COVID?
I know that schools do have policies, and they vary from district to district, but there are policies for students with medical exemptions related to IEPs. I do not know the third part of that about students who have already had COVID, so I cannot answer that one. And the one in the middle, I'm trying to recall. Immunization, that varies from district to district. So that is a school board policy that I cannot encapsulate. Some do, some don't.
Thank you. Are there further questions? Not seeing any hands. Thank you very much. Ken Euring?
Good afternoon. Thank you for the opportunity to speak. My name is Ken Eyring. I live in Windham. And, you know, I'm looking at this from maybe a slightly different perspective from some of the conversations that took place today. I'm a former chairman of the Windham School Board, and I've dealt with parents who are on both sides of many issues. And it's difficult to make everybody happy at any given point in time. I don't look at this as whether this is about masks work or not. I believe that you know, some of the conversations was that this should be dealt with at the local level, that this is a local control issue, and that the school boards have been elected in order to represent the parents. And so therefore the state shouldn't get involved. But as was just brought up, the state has made laws and the state has made rules that have empowered school boards to do certain things. And if those laws and those rules are being violated, if they're not being enacted and implemented according to the will of the people who elected the school boards, who in turn hired a superintendent who's there to represent and implement an education for their children, the answer isn't always going to be addressed at the local level. These people are elected for multi-year terms. Some of them are elected on false promises, and then they're there for multiple years. And it's difficult sometimes to get the school boards to listen to the parents. It's very clear last summer that there was an uprising across the entire country because people were upset about CRT. They were upset about mask mandates. No matter what side of the issue you're on, it's an outrage that our federal government turned around and weaponized our FBI and declared parents who are there on behalf of their children, lobbying on behalf of their children, calling them domestic terrorists. That's where we're at right now, and that's unacceptable. Everybody says when the budget time comes up for our schools that it's all about the kids. Yet I hear people here today saying, well, this is going to cost our school districts if they have to pay for a kid to go to another school that might be better for them. Who knows what's best for the children? Who knows, if you have kids, who knows what's best for your kid? The parents know what's best for their children. It's not a one-size-fits-all. When I was the chairman and I served on the school board, I recognized this. I helped people, just a few, find alternative forms of education for their kids because ultimately these are the future leaders of our country. All of them should be in an educational environment that best suits the child's needs so that they can realize their maximum potential. This should not be a political issue. This should not be about masks, whether you should be forced to wear one or not. Parents should be allowed to decide for their kids. They are their advocates. And if a parent decides that they don't want their children wearing masks all day long, recycling CO2, potentially harmful. Yes, there are studies out there that say one thing and there are studies that say another. The parents know what's best for their kids. And basically what this bill does is it allows the parent to decide what's the best educational environment for their child. And if their child comes home every day complaining to them and crying to them and not learning to their potential because they're bothered and distracted and they're having trouble being comfortable throughout the day, something needs to be done about that. This bill empowers parents to advocate for their child. This bill puts teeth into the words of the parents who go before the school boards and talk to them about their concerns about their child wearing a mask in school because their child is not comfortable, is not getting the education that they need. This bill forces the school board to listen to those parents because if they don't, those parents now have an alternative. And the school districts will pay the price of that, and they will probably lose half of their students. Nobody should be up here advocating to retain the authority of those school boards who violate their oath of office, which is to be the servants of the people. Article 8 of our Constitution says that they are the magistrates and servants, and therefore our substitutes, and shall always be accountable to the people. Without a bill like this, we have already seen proof positive that school boards feel like they know what's best, they don't care what the parents say, and it's time for the parents to be empowered to do what's right for their kids. Thank you.
Thank you very much. Are there questions from the committee? Not seeing any hands. Thank you very much. Okay, next one is Chow Kelly.
Thank you, Mr. Chairman. My name is Chow Kelly. I live in Hooksett, and I'm here to support Bill 1588. My mom was a teacher, and I grew up in a communist country, Vietnam. So the re-education came that Representative David Loves mentioned earlier. My father spent 7 years in it, in a communist prison. It's called a re-education camp, but there's no education. You just work physically hard, and they leave you to die when you get sick. That's what it is. So we lived through it. And I thought I'd come to America, and I have freedom here. But we are becoming like communist country like Vietnam and China and North Korea. And we lived it. Trust me, I know. Other people here that want communists and all that, they don't know jack. I'm sorry, you don't know anything, nothing. If you live through what we live through, you all want to get rid of that ideal, that noble thought that everybody's the same. When I went to school in Vietnam, and I was a good student. My mom always know every teacher, and she frequented my school all the time. And you know what? She know everything that I wrote in school too. To this day, she reminds me what I wrote in my essay. That kind of involvement. And yet, the school said that I failed ethics class because I did not participate in this extra curriculum that the Communist Party insisted that children at a certain age, you have to participate in it or else you're going to fail your class. And I was about to be failed in that class just because I didn't follow every kids have to do the thing that the Communist Party asked everybody to do. So my mom had to allow me to participate in these curriculum things that is nothing to do with education. It's just pretty much that boys and girls get in the circle and they all shaking hands, they all dancing and do all these stupid things that like everybody's the same. But you know what? In my Vietnam, women, girls, and boys, you have to be separate. And we had to be proper. And yet this kind of stuff, taking away the innocence of the child, it ruined the parents' control and it create problem for them to have teenagers, pregnancies and all that, you know? And yet, I was about to be failed for ethics, for not participating in those activities. And here, I went to the Wyndham audit in Concord for 15 days. I am as an adult, and I have been bullied so many times. Every time that my mask happened to fall off below my nose, people like, get it up there. They get into my face and tell me to put it up there. But it's okay for you to take it off and drink your water, eat your apple, whatever. It's okay. But the minute your mask fell off just below here, they came over and stick in my face like that, pointing in my face like that. So I am as an adult. I know how to defend myself. What about these poor kids? You know, there's no emergency. Why do you make the kids have to put all that over their face? That is abuse of children. That's a form of abuse. You know, I went to so many school board meetings. And what Ken Eyring said and David Love said is true. The school board treat the parents like the enemies. It's not funny to watch, like they sit there cocky, like, you know, we listen to you, but just hearing, but we're not listening. And we do what we want anyway. You know, and if you get excited and emotional about your kids, oh, you terrorists, traitors, and all that. That is that kind of abusive to the parents. So we need to protect our children. They are the future. And the party of love and peace always talking about that. But how do you show love and peace without a smile? You can't. You know, many times I go to all these hearings, I don't know who's talking because everybody have their mask on. And many times I cannot understand what people are talking if I don't look at their mouth. You know, it's hard for people to understand what people are talking about. So it's important for us to protect the children. So if mask is a uniform of the school, then why is it that everybody don't have to wear the same uniform? Right? So if I have money in my pocket and I want to go to this store and they say, mask, must wear a mask to walk into this store, I'm not going to spend my money here. But the taxpayers, me included, already pay for all these kids to go to these public schools. If they are not happy with the service there, that imposing on that business, because into those school boards, all they're talking about is the students. I was shocked first time I hear that. Our customers. They're talking our children as our customers. If you, the school boards, treating our students as the customers, then they must have the right to enter that store or not to spend that money. Yet the money already advanced to this store, to this school. So that money must follow the kids to compensate for that fund. So according to this bill, that funding should follow the children and pay for all the extra because these schools don't treat their customer right. And one more thing, the kids, they learn from the young age, from when they were just born, from even in the womb. They hear you, they watch you, they observe, they imitate. So if they cannot imitate what the adult expressing love and stuff like that, how can they express themselves? We're here for the children. Everybody on this board is for the children. You know how important they are. You know, so it's not just about knowledge. You have to take care of their physical, their mental, and their psychological health too. So look at the suicidal rate. And not only that, many children have asthma problem. How do you expect them to have that mask on their face all day, breathing out, inhale oxygen and breathing out carbon, and it's blocked on your face like that, so you inhale back mostly carbon. You're killing the kid with the mask unnecessarily. That's killing. That is dangerous, endangering the child. Those people that put these things in should be prosecuted for the crime for putting children in endangerment. And not only that, you know what? Everybody walk around, the only thing you see is the eyes. We all look like we're in a Muslim country. You know, nothing against the Muslim people. I have Muslim friends. But you know what? This is America. We have freedom of expression. We have freedom of speech. But you're taking away our freedom of expression since the child was a kid. The kids learn to be submissive and not defending itself for what is right and wrong and their common sense. This mask preventing what? Preventing the germs. It's like you preventing a mosquito with a link fence. That's what it is. Whatever study, I don't care. That's common sense. So it's not just about the mask mandate. The money must follow the children in the school. The business, the school must treat the customer right. Reimburse the money and follow the kids. And I ask for your vote to support this bill.
Thank you very much.
Thank you.
Are there any questions? Not seeing any. Thank you.
Thank you. I appreciate it.
Roseanne Chester?
Thank you, committee chair. Thank you, committee members. The only couple of things I want to say about this is that I have found out recently that our school boards, unfortunately, throughout our state, are not necessarily representing the majority of the parents. I'm finding this out the hard way because I'm starting to talk to parents. I know a parent of an 8-year-old who suffers from Tourette's. He has other issues as well. Suffers from Tourette's. His Tourette's comes out through tics. I don't know if you folks are familiar with what tic is, but unfortunately, that mask wearing creates a lot of problems for this child. He has not been able to go to his public school and have his IEP done because his parents say, I will not abuse my child by forcing him to wear a mask. And they've said, well, you just got to keep trying. That's not okay. That is not okay. Well, just keep trying to abuse your child. Just keep trying. Eventually they'll comply. Students are standing up all over this state right now. They are being charged detention and being expelled from their schools because they finally said enough is enough. I want to speak a little bit to the citing of the study that was cited by one of our representatives. This is the first randomized controlled trial. This is from the study that was quoted. Trial exploring whether facial masking prevents COVID-19 transmission at a community level. It's also noted that it's in I'm sorry, I'm not reading the whole quote for time. There's a significant risk of COVID-19 in rural and not well, where I can't find it. So this whole study that was cited is in regards to controlled villagers in a third world country. I just wanted to bring that to the attention of the committee. The bottom line here is we should not be talking about this. We should not be talking about this. Discrimination is discrimination, regardless of whether regardless. Our schools should not discriminate. Our school boards should not discriminate. Our businesses should not discriminate. I'm hearing people from organizations that say it's going to cost a lot of money. You know what? That's still a form of discrimination. The fact that we, the public, are sitting in here, we become more involved, we've come here and we try to speak educatedly on a situation. I come for the children that I know personally, that I've gotten to know through Facebook groups and some of these other groups. And I am disparaged to speak. To me, that is a form of bullying, and it needs to stop. Thank you.
Thank you. Are there any questions? Not seeing any hands. Thank you very much. And this closes our hearing today on 1588.